Good afternoon, all. This application hearing is in the matter of CFI 070-2022 and is being held by way of video conference before Justice Lord Angus Glennie, with assisting the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The applicant is represented by KBH Limited. Lead counsel is Ms. Bushra Ahmed. The respondents are represented by Davidsons & Co. Lead counsel is Mr. Andrew Strasser. Thank you, Your Lordship.
Thank you. Right, Ms. Ahmed, we were in the middle of something.
Yes, Your Lordship. Before the overnight adjournment, we were looking at compromise request 10 and compromise request 11. And
12, I think.
Yes, that's right. My apologies, 12. And we stated that we would endeavour to send Mr. Trotter on your direction a reformulated version. This was done around 6 o'clock UK time, and then it was forwarded on to Davidson and Co. later. As yet, no response has been received, as I understand, but I would be grateful to my learned friend for perhaps a response this morning. And Your Lordship, it was also sent to the registry so that it could be placed before you, before the hearing.
I haven't received it, as far as I know.
Your Lordship, it may be found on your email.
Right. Give me a second. I'll just look on my phone email.
Grateful, thank you.
Oh, yes, sorry. Yeah.
And so, Your Lordship,
do you want me to bring it up on my screen then?
Your Lordship, if you could perhaps have those in front of you.
Yeah, hang on, just make sure that if I open this, I don't close everything else. Yeah, hang on. Yeah, I tell you what, the best thing is if I print it.
Grateful.
Right, I'm back. Yep.
So, Your Lordship, just to make, so what we've done in terms of these requests, we have reformulated them as per the discussion yesterday and narrowed those down with regards to the document, the custodians being the essential people involved. In terms of the date range, we've narrowed that down as well from the 1st of December 2020 to the 30th of March 2021. And just for your reference, that's because the Limited EIFC entity was set up around the 18th of February 2021. And so hence the date of the 1st of December, just before that. And the 30th of March 2021, well, if it was set up by the 18th of December, I beg your pardon, February, then we don't need to go further than the 30th of March. And then the request is that the establishment of Liberty DIFC and the reasons for doing so. So that's the first part of compromise request 10. The second part is, again, the date range is the same, and it concerns the planned or actual transfer of all and any employees employed by Liberty DMCC to Liberty DIFC, excluding...
Date range is not the same. Not on mine.
I beg your pardon. I shall... Let me bring it up.
First one is 1st December 2020 to 30th March 2021. Second one is 1st December 2020 to 1st December 2021. It may not matter, but am I misreading it?
Your Lordship, maybe I've written it, typed it out wrong. I beg your pardon. Yes, the second request is from the 1st of December 2020 to the 1st of December 2021, covering the transition period between Liberty DIFC being set up and the employees transitioning over. So my apologies for that. And then I'm going to also take compromise request 12 as well in this submission, just to short circuit everything, because the submissions are relevant to both requests. And that is just so that I've got it correct. All documents created by the individual set out there.
Same individuals, are they?
I beg your pardon?
They're the same individuals, are they?
They are the same individuals. Yeah. And it is, again, from the 1st of June 2021 to the 1st of December 2021. And that relates to the allocation of office space to the claimant and the claimant's team. And then from the 1st of July 2021 to the 9th of May 2022, the claimant's attendance at the offices of Liberty DIFC and Liberty DMCC. And the reason why we say these requests are relevant is for a number of reasons. My learned friend yesterday in his submission says that there are two issues arising from the pleadings, and that is whether or not there was an oral agreement between Gupta and the claimant regarding the transfer of employment from Liberty DMCC to Liberty DIFC, and to what extent did the claimant have access to Liberty DIFC. He goes on to say, in terms of the first issue as to whether or not there was an oral agreement, the defendants deny that. And in terms of access, he says that that's common ground. But what we say is that those are a very narrowing of the issues that the court has to determine, and ignores really the bigger and larger threshold question that the court will have to determine before it determines the validity of the termination and the damages arising from that, is that, well, it will have to establish the entity that owed the claimant his duties. In other words, what I'm trying to say is that the court will have to determine who the relevant employer was at the relevant time. And so therefore, the inquiry isn't limited to whether or not there was an oral agreement. It's broader than that. And so in terms of, or rather where the defendants deny the existence of an oral agreement, the claimant also claims that an employment agreement arose by conduct. And we say that in that context, the court will be required to analyse, for instance, factors such as operational control, treatment of employees, the functional roles of the entities involved, that is Liberty DMCC and Liberty DIFC, to what extent were they functional and operational over this period of time, and access, and establishment and employee transfers, as well as the decision making around those issues, are all, we say, key factual elements in identifying the entity that exercised substantive employer obligations. And just to sort of put some colour onto that, I have also sent to the court 2 authorities, although I'm not going to take you to them, but I can just explain to the court the proposition arising, well, what those authorities are and the proposition arising out of those authorities. And the first one is Auto Cleanse Limited against Belcher. And this was a Supreme Court decision which emphasised the importance of examining the actual reality of the employment relationship over the contractual label. And the references in that judgment are paragraphs 24, 25, 26 and 35. The second authority is Brook Street UK Limited against Dacas 2004, EWCA Civs 217. The Court of Appeal in that case held that the employer identity may arise through conduct and integration into an organisation, even in the absence of a formal agreement.
I don't suppose either of those propositions as propositions is controversial. It's a question of applying it to the case before us.
Well, I hope they're not, but
well, we'll find out in due course.
So putting all of that together, the point that I'm making is this, that the court will need to analyse the allocation of office space for the claimant and his team, because that would indicate operational control, and whether or not it was Liberty DIFC that exercised managerial responsibilities or Liberty DMCC. Regular attendance would be another factual analysis that would suggest a functional employment relationship. Attendance, location of the claimant's team and their attendance will be further crucial indicators, we say, of an operational employer. And therefore, Your Lordship, that's the context behind making these requests, as well as the DMCC requests. Now, you'll recall when I opened yesterday, I took Your Lordship to part of the order that we're seeking in relation to the DMCC documents that you won't find in the claimant's reformulated RTP. Now, I can deal with those requests now, just because it's sort of following the same theme, or
isn't it better to stick to the scheme we're going down at the moment, which is finishing off this schedule?
I'm in your hands, Your Lordship, however you think might be an efficient use of time.
Well, you know the case better than I do, but
I mean, I can very quickly take the DMCC documents because they are complementary, we say, to these compromise requests 10 and 12.
Okay, yeah.
Your Lordship, if I may, first to give you sort of context behind these requests, you've seen compromise requests 10 and 12 as reformulated yesterday evening. May I take you then to page 485 of the bundle?
Yep, a letter from KBH.
Yes.
Yeah. Want me to read it?
Yes, please. The second page in particular, that's where those requests are. And then there's an attachment to that whilst I perhaps bring it up. There we go. So it's 486 and 487.
Yeah.
Your Lordship, 487 are the particular requests and the reasons for those requests.
Yep.
Your Lordship, the question goes back to the identity of the employer. and
Yeah.
undertaking a factual analysis that would allow the court to infer the correct identity of the employer at the relevant time. And we say that these documents go to the operational capability of whether Liberty DMCC had the practical and legal ability to function as an employer, meeting the obligations and responsibilities typically expected of an operational identity. And just to break that down, at page 487, 1.1, it's the audited financial statements of Liberty DMCC for the financial years 2018 to 2022. That's what's being requested. And
why do you want such a long period?
Well, Your Lordship, I was going to address you on that. Having reflected on that, it is quite broad, and therefore we'd be content to narrow that to the 1st of January 2020 to the 31st of December 2022. And the reason
2020.
1st of January 2020. Now, under the DMCC free zone regulations, under which this company is incorporated, entities are required to file audited financial statements, and that would demonstrate their compliance with the regulatory framework, as well as to, of course, maintain operational capacity to retain their licenses. And therefore, Your Lordship, what we say these audited financial statements would reveal is whether or not DMCC entity had the financial solvency to function as an employer, whether or not it allocated resources to operational activities such as, let's say, payroll, office expenses and compliance requirements. And furthermore, can they demonstrate, or they would demonstrate, financial activity that would support the defendant's claim that the DMCC entity was the relevant employer at the relevant period of time.
Help
And
me
of
on
course,
this. Sorry to ask a stupid question. Are the audited financial statements not available publicly?
no, they're not. No. There is no organisation or institution, let's say like the Companies House in the UK, that holds this information in the public domain. So these are specific requests that would need to be made to the entity for a specific purpose.
Yeah.
And again, 1.2 utility bills, or rather, sorry, the audited financial statements, that would also reveal whether or not there would be payment of utilities and whether or not DMCC was conducting proper financial filings, which is a prerequisite in order to maintain their license. And so we say that.
Yeah, put simply, your case is that DMCC was not functioning.
And it wasn't.
And therefore couldn't have been employing him.
Absolutely, and it was perhaps a dormant entity.
Where is that an issue? I'm not saying it's not an issue, but is it specifically an issue on the pleadings?
Well, it goes back to the broader issue of who the correct identity or who the correct employer was.
I understand that. Is there any specific pleading about the capacity of DMCC to operate and employ people such as the claimant?
Your Lordship, I can't think of a reference now, but but once Mr. Trotter gives his submissions, I'll have a look through the pleadings and see if there is a direct and specific pleading of that nature.
But you say it's covered by the more general point you make.
Yes, which is assessing the correct identity of the employer and therefore undertaking a factual analysis of the correct identity. Going back to then request 1.2, again, for the same reasons, that date range is broad, and we're content to narrow that from the 1st of January 2020 to the 31st of December. And again, I think
again, sorry to keep interrupting. The audited financial statements, you want what years?
So
you don't want to go back to 2018, do you?
No, we want to go back to 2020.
To 2022.
To 2022.
Yeah, okay.
And then moving on to the utility bills, again, these would be useful to examine any operational decline in Liberty DMCC after Liberty DIFC's creation, which would, we say, indicate a transfer of operational and employment responsibilities. And why we asked for the documents pre-February 2021, and that was the date that Liberty DIFC was incorporated, is that it would be relevant to establish to what extent was Liberty DMCC active before Liberty DIFC's establishment, and then assess the period where there was an overlap and, let's say, post-transition, and assess the decline after Liberty DIFC was incorporated. And of course, if there were regular payment of utility bills at the level that of pre-incorporation of Liberty DIFC, then that would infer that the DMCC entity did maintain an office and actively conducted business during the period in question. And so we say that if Liberty DMCC was not paying utility bills or maintaining an active office, it raises serious doubts about its ability to function as an employer during the disputed period.
I see.
And your lordship, whilst I've been talking, I do remember a reference in the particulars of claim, and I think the reference is decanting the employees. I'm just going to perhaps see if I can find it in the electronic bundle. Paragraph 27, I've found it. Sorry.
What page?
Page 142.
Paragraph 27.
Yes. At the bottom, the intention of Mr. Gupta in incorporating Liberty DIFC was to consolidate the management operations of the Liberty Steel Group and the DIFC by decanting its existing staff from the existing premises of Liberty DMCC in the Almas Tower in Jumeirah Lake Towers to new premises of Liberty DIFC in Central Park Towers, offices DIFC.
But that's admitted, though, I think. Am I right?
Not sure if that sentence is admitted.
I thought maybe I'm wrong. I thought from recollection that about 5 paragraphs about the movement of setting up of DIFC were all admitted, but I may be wrong. They did let me divert you.
Yes, you're right, your lordship. That the first sentence is denied. The remainder of the paragraph is admitted. I'm looking at page 176.
Yeah.
Yeah. Be that as it may, your lordship, we say that all of this evidence will go to determining the factual matrix pursuant to which we say that the DIFC entity is the correct employer. And of course, you've got my submissions on that. With regards to request number 2, and I'm still looking at page 487, and this is the DMCC request.
Yeah.
Records relating to the employees of Liberty DMCC between 1st of January 2021 and 31st of December, including names, roles and reporting lines, details of any termination as an employee of Liberty DMCC, details of any transfer from Liberty DMCC to any other entity within the Liberty Group. In my submission, that is also now covered by the reformulation of CR 10(2).
Except the word including is a bit of a dangerous word.
I beg your pardon, my lordship.
The word including, records relating to the employees, including 1, 2, and 3. You want all, in other words, you want all the records.
We don't want the entirety of their HR files, and I think
the way it's drafted is all records, including the various subcategories.
In which case, your lordship,
what you want, I think, what you want is records relating to the employees and showing their names, details, and so on.
Yes, your lordship. Yes.
Something like that. No. You don't want all the records.
That's absolutely right. We don't want all the records.
So should I change including to insofar as
yes,
insofar as showing 1 their names, 2 details, 3 details, so on.
Yes, your lordship, we're content with that.
Yeah.
And then request number 3, still at page 487, we say these are key category of documents required by DMCC. Now, I also accept that it's quite broad to say regulatory compliance and licensing documentation. So just to give a bit more flesh to that, when we say licensing documents, that means the trade license. So a DMCC company, DMCC being the free zone, must hold an active and valid trade license issued by the DMCC to legally operate within the free zone. And so trade licenses are subject to annual renewal. And there's also a requirement to show share capital proof, which is with regards to the changes in the shareholding structure. And we say that's the licensing documentation that we are looking for, the trade license.
How do you define it then? All regulatory compliance and trade licensing documentation?
Trade licenses, yes, trade licenses or applications for trade licenses. So all the trade licenses, including the applications.
Oh, it's your application for an order. I'm not going to draft it for you, but how do you want to what do you want to settle on for 3?
So, well, that just deals with the licensing. Can I address you on the compliance and regulatory documents that we're seeking, and then maybe I can perhaps outline what it is precisely that we want. So when we talk about regulatory, we're talking about annual reports, and that's already covered by the
By 1.
Yes, by 1.1. So, but then in terms of compliance documents, tax and VAT filings. So the requirement on a DMCC company is records of VAT registrations and filings, and that's necessary. And so we also require that. And I beg your pardon, going back to regulatory, what we'd also like is any official communications with the DMCC regarding compliance matters, including any fines, warnings, or investigations.
I think to be fair, we got to call a halt somewhere. Tidying up existing drafting is one thing. Saying, and we'd also like is seeking disclosure on the hoof without any advance notice to the other side. So I'm happy to consider and let Mr. Trotter deal with slight adjustments to the wording of this, but I'm not going to start allowing new categories to come in.
I appreciate that.
On this application, that is.
I appreciate that, and I understand. In which case, let me just specify exactly what it is in the context of the request at 3. Licensing documentation concerns trade licenses and any applications for those a renewal of those trade licenses, as well as any amendments or approvals to them. That's the licensing documentation. In terms of the regulatory, we've covered regulatory. In terms of compliance documents, we're seeking tax and VAT filings.
Okay, but I want something that I can ask Mr. Trotter's comments on. I need some wording from you, which I'll write down in longhand if necessary, so we know what we're dealing with.
Yes, Your Lordship. Can I just take a moment, perhaps,
Yes.
to provide that?
For example, you said regulatory is probably covered by the financial statements in 1.1. So I'm not quite sure why you want it again in 3.
No, that's precisely right. I don't. I want the licensing applications.
Well, just take a minute to write it down and then tell me. Yes.
Your Lordship, I've written it down, and maybe I can read out.
Read it out slowly.
So the request is licensing documents, including the trade licenses and any applications for a renewal of those trade licenses.
Including the trade licenses and any applications.
For renewal of those trade licenses, including any changes in the shareholding structure.
Changes in the shareholding structure seems to go rather beyond what you asked for in 3.
As I understand, when one makes an application for renewal of a trade license, one has to show what the change is. So in any event, it may be redundant if we ask for the applications. And so that last part may be redundant in any event. So happy to strike that out.
So cross out including any changes in the shareholding structure.
Yes.
So what I've got down is licensing documents, including the trade license and any application for renewal of those trade licenses.
Yes, I'm happy with that.
And that would replace the wording in 3.
Well, and then the compliance would be, rather than compliance, we say tax and VAT filings or records of VAT registration and filings.
Stop. A minute ago, I gave you time to write down what you wanted.
Yes, let me read it out to you.
No, I've written down what you told me, and now you say you want more.
Well, the request covers regulatory compliance and licensing documentation.
Yeah.
What I've read out just limits itself to the licensing documentation. There are obligations on DMCC companies to comply with other regulatory regulations, such as tax and VAT filings as well. And to what extent the request really goes to what extent has there been compliance with the obligation to make tax and VAT filings? Because then that would go to whether or not this is a dormant company or an operational company.
Right. I need some wording on which.
May I take?
Wait a minute. We've keep on. You tell me something, then just where I think I've got it, you add more to it. I want simple wording that I can first of all understand. Secondly, ask Mr. Trotter about, and then come back to you for a response. And something I can make an order about. I can't grant an order for 3, for example, if I don't know in writing what it is you're asking for. At the moment, you told me in writing a bit of it, and then you say, as soon as I get that right, you say, oh, and there's also. So let's final version, please. Final version of
Yes,
what you want in 3.
Allow me a moment. My Lordship, thank you for that. Taking
Well,
into account the request, which is at 3, compliance and licensing, let's ignore the regulatory, compliance and licensing. I've broken down the wording in 2 parts. So starting with copies of Liberty's DMCCs, and part 1 is as follows.
Copies of Liberty DMCC.
Yeah, part 1. Active and valid trade licenses. Issued by and I think that the official title is DMCC Free Zone Authority, but I'd have to check that. In the period from
Yeah.
1st of January 2020 to the 31st of December 2022, including any annual renewals and or modifications and or suspensions and or revocations. So that's part 1. Part 2 says preface copies of Liberty MCCs. Part 2, tax returns.
What?
Tax returns.
Right.
Submitted to the UAE Federal Tax Authority.
This seems to, hang on, this is this not going well beyond what's in present 3?
Well, this is the sort of compliance part of it under the compliance heading. So the DMCC entity would have to comply with the Federal Tax Authorities with the tax, to file VAT and tax returns.
We'll finish dictating and then we'll talk about it. Yeah, tax returns. What?
Between the period 1st of January 2020.
Tax returns submitted by whom?
So submitted by DMCC. 2, submitted to the UAE Federal Tax Authority. Between the period 1st of January 2020 to the 31st of December 2022. Including any penalties issued for failure to file.
Yeah.
Those are the 2 parts to the request.
So we've got rid of licensing documentation now.
So the licensing documentation was a broad label, which is encompassed in this new 1.1.
Right, so I can cut out what you told me before about licensing documentation, including trade licenses and applications and so on.
Yes, so
that goes.
So what I dictated now is the request, which we say arises out of compliance and licensing documentation, which is part of the original request.
All right. So nothing that's presently in box 3 stays. It's replaced by what you told me.
Yes.
Okay. Right.
What I've tried to do is, sorry.
You can.
All I was going to say is what I've tried to do is specify really what it is in terms of the documents that we want, because recognising that compliance, licensing, regulatory documentation is quite broad. And so the regulatory documentation is covered by audited financial statements. Compliance documentation is now specified as the tax returns to comply with the tax filing obligations, and the licensing documentation is now more specific with regards to the trade licenses.
Precisely. Yeah, thank you. Is there anything else you want to put forward now, or is it now Mr. Trotter's turn?
Just finally, we've stepped out of the RTP and Schedule A of the order, but these DMCC documents are part of the draft order at 1B.
Sorry, part of what draft order at 1B?
Draft order to the application notice. So page 13 is the draft order attached to the application notice.
Where's the DMCC stuff in the draft order?
1B at page 13.
Oh, I see. So this would replace
The wording at B.
1 and 2, the whole of B. No, sorry, B1.
So the dictation that I've provided would replace 1B Roman numeral 4.
Right.
1B Roman numeral 1-2 is covered by request 1 in the table.
Well, it's covered by 1-2 in the table.
Yes.
Yeah. 4 takes account of what is now redrafted 3 in the table.
Yes.
And what about and 1 remains the same, except has the period been curtailed?
It has, yes.
To what? Remind me.
So 1st of December 2020. Sorry, 1st of January 2020, I beg your pardon, 1st of January 2020.
To the end of...
Yes.
End of 22.
Yes.
So 31/12/22.
Yes.
Utility bills is the same with the same shortening of the period.
Yes.
That's three is something we've looked at already.
Your Lordship, 1B3 is request 2 at the table at 487.
Yeah.
And the wording of including has been changed to insofar as showing, etc.
Yeah. And that same period, the period the same?
Yes, the period remains the same.
January 2021 to December 2022.
Yes.
Okay.
And then, of course, 1 Roman numeral B4 of the order has been changed to the wording that I've just explained. Yes.
All right. Well, sorry, I'm being rather slow. Where does the stuff we've been looking at in the previous schedule yesterday? That's in 1A.
That's Schedule A.
Yeah, as revised in the course of discussions.
I beg your pardon, Your Lordship.
As revised or rejected or whatever in the course of discussions yesterday.
So that was so these DMCC documents stand outside Schedule A because Schedule A focuses on the request to produce, and so we've stepped out of Schedule A. But for your reference, Schedule A is at page 17.
Yeah.
And going back to the start of my submissions this morning, we were dealing with compromise request 10 and 12, which is at 21 and 22 of the application bundle in that Schedule A.
Yeah, okay. Thank you. Anything else before I turn to Mr. Trotter?
No, my lordship, thank you.
Mr. Trotter, it's your turn.
Thank you, my lord. Well, we've travelled some distance from where we were in my learned friend's application.
We have a fair way. I've tried to keep it on the rails.
I'm very grateful, my lord. And there is a sense in which we welcome the narrowing of the requests into something that's a little more focused. But it is a pity that that didn't happen in the Christmas Eve application, and it has made it somewhat difficult to take instructions on them. My lord, I say without criticism of Ms. Ahmed that they were received at about 10 p.m. Dubai time last night. And it's not a criticism of her, but not everyone is as industrious as Ms. Ahmed. And in practical terms, it has meant that we've had this morning in Dubai to take instructions and make inquiries about what's involved in my learned friend's new proposals. Unfortunately, the person who can give us that guidance is travelling on business, and so has not been accessible to ascertain what would be involved in extracting the mailboxes of particular individuals and the volume of documentation that would be involved and so on. Now, as regards the various new proposals this morning...
Just on that point, it's fair to say that your general instructions would cover the difficulties of investigating the records held by various individuals and so on.
Well, I'm going to try and extrapolate from such instructions as I have in order to give the best information to your lordship that I can, but there are some new people, some new time periods and so on. Okay. So as regards to the new proposals that have been made this morning, those behind me virtually are trying to work out now what can be done and what can't be done, and we will try to be constructive in relation to those. But
do you want a quarter of an hour break so you can talk to them?
Well, my lord, I think we can use the time in the meantime productively, because what I'd like to do is to make some comments about the new formulations themselves and propose a constructive way forward in relation to them, starting with compromise request 10 and 12, and then moving on to the DMCC documents, because the right approach in relation to them may differ somewhat. Now, turning to compromise request 10, and this is all about
this is one I got this morning.
Yes, my lord. It's about the establishment of Liberty DIFC and the suggestion that other employees, some broader scheme to transfer employees from one to the other.
Yeah.
My lord, we went through the pleadings yesterday, and I'm not going to traverse all of that again, but just as we look at the formulations, there are three things that I would ask your lordship to bear in mind.
Yeah.
First, these requests are, on any view, some steps removed from the core issue in the case. Yeah. And my learned friend mentioned some authorities. I'm not going to embark on a debate about the law of contract in the DIFC at this hearing, but the core issue with the claimant will be whether there was an agreement, as pleaded, to transfer him from one company to the other, or whether the way in which the employment relationship was carried out means that there was an agreement by conduct, as pleaded. Now, my learned friend says, well, there might also be an issue about the transfer of employees in general. Well, that's one step removed if my learned friend thinks that there's some inference that can be drawn from that about whether the agreement with the claimant was in fact reached or not. And
it might be said it gives a context in which the treatment of the claimant himself can be assessed.
Yes, in a sense, my lord, perhaps that's a better way of saying the same thing. But it provides the background or context or material from which it can be inferred that the claimant was treated in a particular way, or which sheds light on the way he was treated as emerges from the evidence. I accept that, but it is the background material. And then when one gets to the reasons for establishing Liberty DIFC in the first place, then we really are another step further removed in the background that's likely to meaningfully inform what the court has to decide at trial. That's the first point that I wanted to make. The second is that to the extent all of this matters at all, there really is already a good deal of common ground on it in the pleadings. And we looked at that yesterday. I'm not going to go back to it, but I make the observation that the common ground that there is not just a single proposition, is a number of paragraphs that we went through, and a summary will emerge from those paragraphs, which does go quite a long way to providing the context or background that are necessary for these sorts of points. And then the third point is that viewed against that background, the time available between now and the trial in March is a finite and precious resource. And every day a member of our team is sent off searching for more documents that might or might not ultimately be useful. It's a day that they're not progressing other work streams. And to put it neutrally, the interests of the parties in that regard are not aligned.
Mm-hmm.
Now,
by which you mean that the burden will mainly fall on your side?
Well, by which I mean it is, one can see the forensic attraction from the claimant's point of view of diverting personnel on our side to further document searches. I don't put it any higher than that. I'm not suggesting anything improper, but the proportionality point needs to be viewed in the context of, we're not just talking about a waste of cost, but we're talking about there will be a prejudice to the defendants in their trial preparation the more of these exercises accumulate. And so that's just the background against which I want to look at and assess the compromise requests that are now being proposed. Now, if we start then with compromise request 10, perhaps it's useful to just look at the old request against the new one. And so the old request is in the table we were looking at yesterday.
Yeah. Page 21.
Page 21, yes. My lord's ahead of me.
Right.
And so, and if I'm not sure if my lord has the new request open alongside it.
Yes, I do.
So, sort of game of spot the difference, but the key changes, my lord, are these. The request 10.3 in the original compromise request is gone, following our discussion about that yesterday.
Yeah.
The date ranges have been narrowed somewhat, although as my lord observed, the date range for the second one is still 12 months, whereas the first one is 4 months. And the practical consequence of that is that the process will involve harvesting the documents from these various custodians and reviewing them for that 12-month time period. And even if we're only looking for the first category of documents within the first earlier time period, the exercise involved still requires the same review of 12 months worth of documents.
Yeah.
Then we have the list of custodians. My learned friend didn't give any explanation for the selection of these people. There are some references to various people by first name, Greggy, for instance, Vanessa.
Yeah.
In some very preliminary inquiries overnight, we think that these people are administrative staff, but it's not clear why they're of particular relevance, and we haven't heard anything further about that this morning.
Presumably these are just names that appear on various emails or something. But Greggy and Gregory are presumably the same person.
That was my working assumption as well, Miller, but I just don't know.
No. Okay.
Yes, they are.
They are the same person.
Yeah,
are they?
yes.
Right. That's helpful. And then the formulation of the introductory comments is still quite broad. So it's not just communications between these 6 or 7 individuals, 6 individuals, but it's all documents created by any of them, any iterations of those documents, as well as communications in between each combination of them. So, as I say, in terms of practical difficulties, because of personnel restrictions in the few hours we've had this morning in Dubai, we haven't been able to estimate the number of documents that would be extracted for these particular custodians. But I can give some rough estimates based on my instructions, because we had made the inquiries for the earlier period for September 2017 to 1st of May 2018. And your Lordship might remember that we discussed that earlier time period yesterday.
In the context of different custodians.
Yes, that's right. So yeah. different custodians, some of them are the same. But it's quite rough and ready, I'm afraid, but the best I can do is to say that Mr. Gupta's mailbox during that period in 2017 to 2018, it's quite a different period to this one, but no particular reason to think it would be different, contained, we're told, about 5,000 emails per month during that period. So extrapolated over this 12-month date range, that's 60,000 emails for Mr. Gupta. We then have 6 or 5 other custodians. So we're talking something in the region, if their counts were the same, of 360,000 emails. Now, in reality, I suspect, although I don't know, that other people in the organisation might have lighter email traffic than Mr. Gupta, given that he's a very senior individual. But I just don't know how much less. And on any view, those numbers are going to be quite high. Now, it may be that they can be filtered down, maybe that they can be deduplicated in some way, but there will be a large number of documents to deal with. Now, that creates 2 problems. First, we're not really in a position to assess at the moment whether the proposal that's been made, in the terms it's been made, is reasonable and proportionate, because we just haven't had the chance to get the information to do that. And the second and related thing is that we therefore don't know how long it will take to address these queries. So we can't address your Lordship on the appropriate timing. But I don't want to just be obstructive. I'd like to be constructive. So I think we've thought about how this could be taken forward effectively. And it seems to us there are really 2 sensible options. Mm-hmm. The first option is that we take these instructions and we write to my learned friend. It is now at any rate common ground that the application as formulated on these issues is not the appropriate order. So if we make those requests and write to my learned friend's firm as soon as we can, whether it's feasible and if so, by when, and if not, what we propose to do, then if my learned friend's not satisfied with that, then a targeted application can be made along with the others that have been foreshadowed in the course of this hearing. But that's the first option. Another way through would be to make the order in some form now, subject to certain tweaks, I suspect, to the drafting of it, but then to make it expressly subject to the assessment of reasonableness and proportionality. And then what happens is we make the inquiries, we produce what we can sensibly produce, and we explain in the document production statement what it is that we've done in the usual way. And then the claimant can review what's been produced, they can read the document production statement, and they can take a view about whether anything further is required. Now, the problem, of course, is timing, because, as I say, in a sense, we don't know what will be involved. I'm told just now that for every 10,000 documents, 2 weeks will be required. And the numbers I was ventilating before are much in excess of 10,000. So they would need to be filtered down very sharply in order to make it even remotely possible. But in a sense, the timing will guide the reasonableness and proportionality. So if one were to say, well, we'll see what we can do in a further 2 weeks, we'll assess having taken those instructions, and then we'll produce the document production statement, then anything further can be sought on a fully informed basis. It seems to us that that would be a sensible way to find a way through this issue.
I think the second of your options sounds of those two options, sounds the better bet. I'm not tying this argument to anything in particular, any response in particular, but to make progress in having an order which can be complied with to a large extent or a significant extent, and with the caveats you mentioned, seems to be a better way than simply writing in a couple of weeks' time or whatever.
Yes, well, I mean, if that gives my learned friend more comfort, then we're content with that. I mean, in a sense,
well, before going down this road, I better check that Ms. Ahmed equally prefers that course, because if she prefers your letter writing course, then I can abandon all thoughts of option 2. Ms. Ahmed,
yes,
do you prefer option 2?
Your Lordship, of course we do. I mean, the whole purpose of this application was to get the defendants to engage with us. So, and again, all we're asking for are reasonable searches and a document production statement telling us exactly what they've done and how they've conducted those searches. So, yes, the second course option is far preferable than the first.
Let's pursue our option 2 for the moment. And don't worry, I'm not shutting you up completely, Ms. Ahmed, but we'll come back to it when I've heard from Mr. Trotter in more detail.
Thank you, my lord. And I should say, this particular category of document are not, I think, somehow critical to my learned friend's witness evidence, because the categories, in fact, in terms, don't affect the claimant personally at all. They're all about the establishment of the business and the conduct of other employees. So, I mean, my lord made the observation earlier in the hearing that the witnesses can only speak to what they know anyway. But in a sense, this is a category that really doesn't affect witness evidence. Now, so I think if the I can come back then and address my lord on the terms of the order. Yeah. I think most critically, it needs to be prefaced by the words insofar as reasonable and proportionate, because that assessment. The critical point is that we just haven't had the chance to make that assessment. And in a sense, that's why I put option 1 on the table, because it would give my learned friend sooner the opportunity to see what it is we're proposing and to engage in that debate. But if my learned friend prefers option 2, for us to go about the exercise, produce what we can, and then write it up in the document production statement, then I can see the virtue in that, because then my learned friend can actually see the documents that are produced and consider not just in theory, but in practice, whether anything else is required. So
the alternative would be to make the order with a proviso that you could apply to the court in the event that after further inquiries it seemed unreasonable and disproportionate.
Well, my lord, that there's the wrong way around.
It builds in a further hearing and expense and delay.
It does. It's bound to create further satellite disputes in this litigation.
Yeah.
It puts the onus on us to apply in circumstances where we have been landed with this proposal at very short notice, and we're trying to make proposals to move forward constructively, not to create further disputes.
So you're saying insofar as reasonable and proportionate, then whatever follows.
Yes, and then in my submission, and especially given that we haven't really had a justification for these various individuals, as long as it's prefaced by as far as reasonable proportion, I'm content with that. But a more sensible formulation of that introductory paragraph would be limited to the communications passing between those individuals, because otherwise we're trawling through every document created by all of these individuals.
Hang on. The other thing that occurred to me, sorry, just if I can chip in while it's on my mind, is we know nothing about Vanessa, Greggy, or Gregory, as far as I know.
Well, right.
And could one, for this purpose, delete them?
Yes,
Your Lordship, I do have instructions here. I'm being told these are admin people. So Gregory is the person who sat at reception. Vanessa is the office manager. Jessica, as well, is somebody from front office. And I think I've covered.
Would they be likely to have any sensible, any useful material?
Well, Jessica apparently from front office, and that comes from a WhatsApp. No, it's not clear to me whose WhatsApp. It must be one of the claimant's WhatsApps that he's disclosed, because the claimant is the only party that's disclosed any WhatsApp messages. And I'm being instructed that on the 9th of September 2021, there was a WhatsApp message referring to Jessica from front office, who created a group for the entire DIFC-based GFG Liberty team for the purpose of sharing important information regarding Central Park Towers procedures, updates and events.
That was Vanessa or Jessica?
That was Jessica. So I beg your pardon, let me just read the rest of the WhatsApp message. So Jessica from front office has created the group. I've already said that. Then just reading directly from the WhatsApp message, please note that only admin can post, admin being myself, Greggy reception brackets, and Vanessa brackets office management. This is to avoid any spam posting occurring. If anyone has any important information to share or any colleague to add to this group, please forward the details to one of the admins. Have a lovely week and best regards to you all. Stay safe and take care.
Okay, well, I'll go back to Mr. Trotter. I'm not sure, in light of that my suggestion of cutting out Greggy and Vanessa is necessarily the right one.
Well, perhaps not, my lord. I mean, we've received this overnight with reference to a Greggy, in a draft order, and then I've heard on instructions a quote from a document that I've never seen in reply.
I haven't seen that. Yeah.
So it does put me in quite a difficult position. But I mean, I've discussed with those behind me very briefly, and again, we are trying to be constructive about this, but so long as the request is prefaced by insofar as reasonable and proportionate, then what we suggest is that my learned friends write to us and tell us why they think these people are important, because that will help us assess to what extent we need to put emphasis on searching their materials. Because at the moment, all I have is a list of names, some of them first names only, and a document that's been read out from the bar table by Ms. Ahmed. So we're perfectly happy to engage on this and to look at the communications and to produce them if it's reasonable and proportionate to do so in the time that we have. And it strikes us that if further detail can be given to us by my learned friend about why they think that's the case, that would be a good thing.
Ms. Ahmed, does that sound sensible? So do you mind me going back and forth between you?
No, not at all. But there are. But I mean, I can deal with this in the submissions that I make generally to the points that Mr. Trotter has raised, or I can deal with this particular point now.
This particular point.
Well, Your Lordship, in terms of who are the individuals, well, we can perhaps provide further details of that in correspondence. And it may be, just as Mr. Trotter has been constructive, it may be that we can also write and agree search terms between ourselves, including names as well. So we're happy to agree that post-hearing.
What we don't want to do is have a week or two spent trying to agree, but failing to agree search terms, and then we're 2 weeks further on with nothing having happened.
Indeed. No, I agree with that, certainly.
So, but if so, you would be willing to give a explanation of the individual's relevance and where the prioritization should be. I think that's
yes.
what Mr. Trotter was
Yes,
asking.
Your Lordship, and we can certainly perhaps agree a timeline as well. So, for instance, within 3 days or 7 days, we agree as to the necessity of the individuals, and if we can't, perhaps we can revert back to Your Lordship, obviously not in an application, but maybe write to Your Lordship as to the areas of dispute and allow Your Lordship
I'm not going to micromanage the disclosure process. I think this has got quite managerial already.
Well, Your Lordship, in the first instance, we would say, arising out of this WhatsApp message, which is in production, that these individuals are relevant. If it's just a question of identifying them further with surnames, we're more than happy to do that.
But it's a question also if Mr. Trotter's team are going to be looking through maybe up to 5,000 emails per month per person. It's better that they have a priority list, so they know what they're really being asked to do.
Indeed, and we can provide priority lists.
My Lord, in a sense, this is why I proposed option 1 to begin with. Now, I'm content with option 2, but I'm wary of this sort of blend of the two of them. If we're going to do option 2, the idea is that my learned friends should write to us and give us information about what they consider is appropriate. But the team on our side needs to be able to move forward with the document production process, to look at the documents, to make judgment calls about what is sensible to prioritise. We're perfectly happy to take into account information that's forthcoming from the other side, and we would welcome that. But what we don't want to do is to have the whole process held up by more micromanaging disputes about what keywords are going to be applied and so on. If we do want to take that...
Sorry, Karen. I was just going to say, I wonder whether the best thing is not to have built into the order sort of extra right to Y within 3 days and so on, which is just going to cause problems. Better thing would be to, if I made the order with the preamble insofar as reasonable and proportionate, and leave it to you. If they want to send something to you saying, please focus on X, well, they can do so, but that's not going to be part of any order.
That's exactly right, my Lord. I'm sorry that I was imprecise, but I certainly wasn't suggesting that we embody any requirement for my learned friends to write to us in the order. I was merely inviting them to do so. Yeah.
Okay. Happy with that, Ms. Ahmed?
Yes, Your Lordship. And when I do read the compromise request, I think it's quite clear the order of priority in terms of who the defendants ought to prioritise. Obviously, it's Mr. Gupta is first, Ms. Timms is second, Evan Allen, and so forth. And so the compromise request or the formulation thereof themselves provide an order of priority.
All right. Although I think Jessica seems quite important now on what you told me.
Yes.
Anyway, I won't put forward my own view as to who might be more or less important. Okay, so insofar as reasonable and proportionate.
Thank you.
Documents passing between the individuals there?
I think the best course is just then to delete the first part of that introductory passage, because then we have communications passing between and then the relevant individuals. Apart from anything else, that of course brings down the document count very significantly, because you don't just have every email that they're sending to anyone in the world. And that will of course include any attachments to those emails, which is likely to bring in any other relevant documents.
That sounds sensible, doesn't it?
Sorry.
What you want is communications between these people. Otherwise,
not only that, Your Lordship, we also want documents created by particularly Mr. Gupta and Ms. Timms, because if these are sort of decisions as to around the establishment of Liberty DIFC and the planned actual transfer, for instance, when we look at compromise request 10, then that would also include minutes of meetings and notes.
If you get communications between, say, Ms. Timms and Mr. Gupta, and they refer to something which isn't included in the message, then you can ask for it.
Yes, Your Lordship. My concern there is that what if there were meetings and minutes of those meetings as to the decision making around the transfer and the creation of the DIFC entity, but they're not referred to in emails, let's say, or they haven't been sent on, and therefore we lose some category of documents if they haven't been referred to, let's say, in emails or communications.
My Lord, the thing about minutes of meetings and documents is that they tend to be sent by email to people. We've also disclosed a vast number of meeting invites, and in a sense, I mean, we do have limitations here of what can feasibly be done in the time available. So it seems to be at least a sensible place to start is the communications between these people. Then, if having reviewed what we've produced, my learned friend thinks that there are things that are missing or categories of things that are missing and remain important, then they can write to us about that.
It's most unlikely that I take your point, Ms. Ahmed, about minutes of meetings not necessarily being subject to sent by email, but it's unlikely the email correspondence will omit altogether any reference to a meeting. So if you knew there was a meeting and haven't got the minutes, you can ask for it.
I take your point. So may I just address you on this point about limitation in terms of kind of what the team of the defendants has to do? I mean, one of the points made by my learned friend is that there's a lack of personnel and there's an awful lot to do. Your Lordship, if I perhaps can remind you, Mr. Swangard's witness statement talks about a third-party consultant that's taking undertaking the review. Not only is there a third-party consultant involved, but the defendants have engaged Mishcon Dorea and their e-discovery platform. So we have two external resources here.
I've got that point, Ms. Ahmed. But the thing is, we are where we are. There's a lot of work to be done. Who's to blame for it is not my present concern. Whether more could have been done in the past is not my present concern. We've got a trial fix for the end of March.
Yes.
And we've got to work towards that. And it seems to me that if you ask for too much, you end up getting nothing.
Indeed, Your Lordship.
It's not a threat. It's just a reality.
Your Lordship, I completely take your point, and it's a very fair point to make. My only concern is, and Mr. Trotter has said that like meeting invites have been shared. The problem with those meeting invites, as I understand, is that there's no context behind them. So we don't know what the purpose of those meetings are, firstly. Secondly, I appreciate what's been said about communications and emails. There's an assumption that there will be some reference somewhere in those communications of a meeting. But the question is, what if there isn't? And these are all documents in the defendant's possession and control, and therefore, if not documents created, at the very least, if we could have something about documents related to the decision making of the establishment of Liberty DIFC or the planned and actual transfer of all employees, and then communications.
That's what's covered. Communications passing between these various people from those dates concerning the establishment of Liberty DIFC and the reasons for doing so. Isn't that?
Yes, you're right. Communications is, I've just looked at the definition at paragraph 17. You're absolutely right, my Lordship, and thank you for reminding me of that. So we're content with communications.
Okay, so we'll delete the first line and a half of compromise request 10. We preface it by insofar as reasonable and proportionate, and stick to those dates. Is that for item 1, 1st December 2020 to 30th March 2021, Mr. Trotter? Does that seem
well,
right?
my Lord, in a sense, the first date range is in a practical sense immaterial, because it's the wider date range that will govern the scope and burden of the exercise. The 1st of December 2020 to 1st of December 2021 in the second category, the second number 1. Now, of course, we've been told in the course of argument in this hearing that there's some idea that there's been a general transfer of employees. It's of course not pleaded anywhere, so it's not pleaded when or how or during what time period this supposed scheme operated.
Right.
And so we're really shooting in the dark when we're looking at what the time range is. All we know is that Liberty DIFC was incorporated in, I think, February 2021. So one would hope that there might be a bit of scope to narrow that date range to alleviate the burden. But I can't really say anything of principle about when the right period is, because, as I say, there's been no pleading about it.
Well, I'd have thought that
I mean, what I can say is that the defendant is said, sorry, the claimant is said to have been transferred in July 2021.
Yeah.
So, you know, it may be that a date range that runs through, say, September would be sufficient. But
I doubt that will save you very much, in fact.
Yeah, I agree.
I wonder if we should just keep to December 2020 to December 2021.
And it may be that in the course of the document review, I mean, these things are always quite dynamic. Once you get into the documents, you see where the relevant activity is. And it may be that the proportionality and reasonableness caveat can kick in there, and we can make judgment calls about how to prioritize document review.
So I'm inclined to keep the December 2020 to December 2021 for the moment and apply that to both. There's no point in having different date ranges. I'm talking, when I say both, I mean both parts of compromise request 10.
I think there is it's difficult to say that it will have no impact. I mean, my point is that the broader date range sets the parameters of the entire exercise. It's entirely possible that when one gets into the communications, for instance, we discover that the documents relating to the establishment of Liberty DIFC are in particular between 2 or 3 individuals. And so it's more appropriate to focus on those communications over a particular time period. I can see why my learned friend has suggested December 20 to March 2021, because that's a month or so either side of the establishment of Liberty DIFC. We're not going to discover much about why the company was established a year after the fact, whereas the activity will all be around the time it was done.
Yeah.
So I'm happy with those date ranges and the way that they've been expressed. And then, as I say, we can take a view.
Okay. So are we then happy on the whole of compromise request 10 as subject to the points we've made already?
I think so. There's one very minor point, which may not matter very much, but the words or iterations thereof at the end of the introduction. I'm not quite sure I understand what's meant by an iteration of a communication.
I thought it was an iteration of a person.
Well, that would be even more entertaining.
Miss Ahmed, what is or iterations thereof?
The iterations of the communications, so the various versions of the communications that may have been created.
Well, then it's covered by communications, isn't it? And I don't quite. If
I think what it's trying to capture. No, I was completely wrong. Apparently, the iterations are the various sort of names given to any particular individual. So, for instance, where Gregory is the same person, he's also referred to as Greggy. And so it may be that the individuals are called by different names. And I think that's supposed to capture that.
So it is. So I was right.
My lord was right. I think, I mean, this may really not matter very much, but the word Vanessa, for instance, we're not going to search every Vanessa in the organization. So these are not sort of stuck keywords.
When you get to Vanessa, you're going to look for someone who seems to be in a relevant position.
Or rather hoping my learned friend might tell us who the relevant Vanessa is, rather than sort of trawling through every Vanessa. But the point is that I think we understand each other, that the people who we're searching for are the ones listed there, known by whatever alias they might go by.
We'll leave in or iterations thereof, just because it introduces an element of uncertainty, which is quite good.
Yes, always just what this litigation needs.
Right. So, but with that, on that basis, are we happy with compromise request 10? As I say,
Yes,
subject to the introductory wording we've talked about.
There's no house of objection from behind me, so I think we're one more request down, a few to go.
Oof. What about compromise request 12?
So compromise request 12, I suspect a lot of the same considerations will apply, but if we perhaps just do what we did before and look back at the original request in the table, this one's at page 22 alongside the compromise request.
Yeah. So compromise request 12 on screen at page 22 is records related to allocation office space, attendances officers, and the mailing list.
Yes. And so again, we've got the same introduction in relation to custodians.
Yeah.
So I think the same observations apply there.
Starter communications.
And insofar as reasonable and proportionate.
Yeah.
The date ranges have been slightly narrowed from what was previously in compromise request 12.
Yeah.
And then the differences, which my lord pointed out yesterday when we were looking at this request for a different purpose, is we have reference to, there's two differences in the material scope between the compromise request, both as originally framed and as framed this morning, and the proposal that we had made a couple of columns to the left. And the two differences are
A and B of the original were the same as yours, with a couple of words different.
That's right. And so the first is the claimant and the claimant's team has been included.
Yeah.
Now,
anything wrong with
as
that?
we saw, well, only my lord, it's not really a major point, but as we saw yesterday, it's common ground that the claimant was in a global role and had individuals who were employed by Liberty DIFC, not just after the transfer, but throughout, reporting to him.
Yeah.
So in a sense, we struggle to see what more this is going to add. But what it is going to require is looking into the records of a significant number of other individuals. So it's just a few words, but it is an additional job. And then the second in B is the addition of not only the attendances at Liberty DIFC, but also the attendances at Liberty DMCC. Now, of course, there's no pleaded issue about attendances at DMCC, but I anticipate, although it's not said anywhere yet, that the point will be made that it's a question of relative attendance. You have to look at how much is attending one place versus attending the other.
Yeah.
In order, and that's going to be somehow said to give rise to a change in the employment status. Yeah. And so we are content to search for records of the claimant's attendance at the DMCC offices insofar as such records are available. So don't take a point about that.
And
then
hang on. But the records, where are these records?
Well,
so what if we've deleted? I'm not saying we have, but if we delete the first line and a half of the request, that's the documents created by these people, and limited to communications. What records are we then talking about?
Yes, I think my lawyer's right, and I suspect this is just an infelicity of drafting, because what my learned friend wants is not communications about the records. I think she wants the records themselves. And so it may be that the preface should only relate to one, and that two should simply read as it did in the original compromise request, records in relation to the attendance. And then there's no longer an issue. I'm sorry.
So just so I've got this right, what you're suggesting there is the for 12, we start with word communications, the second line.
Yes. So insofar as reasonable and proportionate.
Yeah.
One, communications passing between, etc., or iterations thereof, and then that will just run straight into what is currently numeral 1. from 1st of June 2021.
Yeah,
and then
so
two.
that's communications about the allocation of office space and so on.
Yes.
And then
yes.
2 is records from 1st July to 9th May in relation to claimants' attendance at the offices of Liberty, DIFC and DMCC.
That's right, my lord.
Ms. Ahmed, does that seem sensible? I think it's really just redrafting rather than any substantive point of principle.
It is, Your Lordship, but I do want to address you on the sort of wording of insofar as is this reasonable and proportionate. So I was going to allow my learned friend to finish and then address you on a couple of points that my learned friend has made. But with regards to, so that's a point of principle in terms of the preface, but in terms of the records that we want, my learned friend is absolutely right. We are just seeking records of the attendance at those 2 entities.
Yeah. Okay. What did you
My
want
lord,
to say? Sorry,
that observation gives me some concern because, of course, the words insofar as reasonable and proportionate, that is the option 2 that I proposed at the outset, and I thought we were all now proceeding on that basis.
I thought we were too. That's why I'm going to ask Miss Ahmed to say what she wants to say.
Your Lordship.
It's implicit anyway, Miss Ahmed, isn't it?
Well, it's
disclosure.
Absolutely, it is implicit. But if I go back to the rules and look at what the document production statement requires, it's to carry out a reasonable search.
Let me get my book.
Yeah.
$28, is it?
Yes, 28.20. And I'm sorry if I didn't make this clear, but I assumed I was going to get an opportunity to respond.
Yeah,
I would reply fully. So, Your Lordship, there's no issue with insofar as the word reasonable search is concerned. It's the issue with proportionality or proportionate. Yeah. And whilst Your Lordship is correct, it's implicit in the rules that any search should be reasonable and proportionate.
Well, proportionate is a necessary ingredient of reasonableness. It's not reasonable to carry out a search for something which is wholly disproportionate.
That's a fair point.
They're often flies at the same coin.
That's a fair point. My only concern is when we get the production statement and the criteria that's set out at 28.20, it just simply refers to a reasonable search.
Yes.
And if we consider on the back of that document production statement that there hasn't been a reasonable search and we take issue with that, I'm concerned that there might be a submission back to us to say, well, the order that was made was reasonable and proportionate search. But I get your point about it being implicit and you can't have reasonableness on its own. But that's really something of concern. And that's what I'm raising, Your Lordship, today, in case there is some contention about the searches themselves once we receive the document production statement.
As I understand the point about proportionate here, that you've got 7 named individuals, well, partly named individuals, who might have massive mailboxes, might not. Maybe their mailboxes largely cover other things entirely extraneous to this area of the case. There's a question of reasonableness in focusing on X or Y. There's a question of proportionality in deciding whether to go to the nth degree on Greggy's inbox, or whether to really focus more on the central characters. And it seems to me that in this context, they cover the same sort of area, but it's important to recognise that proportionality is relevant here with 3 months to trial.
Your Lordship, I take on board that comment, and it's entirely fair. I just wanted to flag that up, but that where there is reference to providing a document production statement, it is only limited to reasonable search, 28.20. But I get the point that reasonableness and proportionality have to be sort of at the back of the minds of the defendants when they undertake these searches. So I take that point. Okay.
So are we happy then with to leave in, happy or not, I don't care. Are we going to leave in the introductory wording? Yeah.
Yes.
All right. Now, Mr. Trotter, do you want to, is the next thing to go on to what we were talking about this morning?
DMCC.
DMCC.
There's one point that's just been lost in there a little bit, which is in compromise request 12, the reference to the claimant's team, because I don't want to go back through the pleadings again, but the claimant's in a global role with people reporting to him all over the place, and some of the people are very senior. He's held a very senior role as CEO of various business units around the world, and the allocation of office space to everyone in the claimant's team, if it involves searching their names across all of these various custodians, it potentially becomes quite an unwieldy exercise. And really,
there's office space within DMCC, isn't it? Sorry, DIFC.
Yes.
It's not around the world.
No, it's not. It's DIFC, and the issue there is the defendants have taken a position that nobody was allocated office space and that everybody was hot desking. And so the claimant's position is that's not true and everybody was allocated. And I think this request goes to that contention.
So, Mr. Trotter, we interrupted you.
No, my lord. Well, again, I'm trying to address this as it arises, so I'm waiting for instructions from behind me. But what it then means is we're searching for the allocation of office space in relation to some subset of the claimant's team, just the people from the claimant's team who are in the DIFC.
The people to whom office space was allocated.
So then at least the request for good order then should read in relation to the allocation of office space at Liberty DIFC to the claimant and the claimant's team.
That's what I've understood by it. So at Liberty DIFC. Yes. Sorry, that's how I read it, and it didn't seem to me likely to cause any problems on that basis.
Thank you, Will. I think the consternation that's coming from behind me is that it's quite difficult to ascertain exactly who is in the claimant's team, but it may be that that's something that we can pick up offline without having to worry.
That will go quite low down the list of controversial matters, but never know.
Yes, one hopes so. All right. Well, then the next thing we come on to then is the DMCC documents.
I'm assuming, by the way, that between your two teams, and I've got a rough note of what we've been deciding and agreeing, I'm assuming that you've got notes that are capable of being sorted out by agreement between the two teams, and assistance given to Alia or whoever else is handling the matter to draw up an order.
Yes, my lord.
Yes, my lord. Yes.
Thank you. Do we want to do DMCC now?
That seems like a convenient place to go.
I've now lost what page we are on.
So that it may be that the draft order is the best place to look at them. They're in page 13 of the bundle.
I've got here we are. Here's the draft order. Yeah.
Now these have also been the subject of quite substantial redrafting this morning. So I hope that I've got everything. But I'm sure some will come.
This is going to take a few minutes. Can we have a 5-minute break? Or 10 minutes?
Yes.
Is that?
Your Lordship, may we have 10 minutes, please?
Yes, 10 minutes. Happy with 10 minutes?
Yes.
It's now 10:40 UK time. So it's 10:50 or 14:50. Thank you. Yes, thank you. We're both ready?
Yes, my lord. So we're moving on to the DMCC documents.
Yeah.
My lord, these are said in terms to be an expansion upon request 10 and 12. We've just been through them in some detail and they've been narrowed at my lord's urging overnight. But we're in the opposite territory here because these requests haven't been narrowed overnight. There's been a bit of drafting orally in the course of submissions, but fundamentally their purpose is to expand upon and elaborate upon the requests that my learned friend was urged to narrow. So as I work through them, I think there are some points that being constructive in light of the redrafting can be produced easily enough, but there are others where we're really straying into the realm of a fishing expedition that is going to be a distraction, even if the documents are produced.
Can you just help me on one thing? I was looking at the document with Ms. Ahmed, and I can't remember what page it was. Not Annex A, but the one that deals with DMCC.
I can assist your lordship. It's page 487.
487. Oh, there it is. Yeah. So my notes are all over the place.
This is the table. Yes. And then the same requests are also in the order at page 13.
In precisely the same words.
Well,
effectively, yeah.
I believe so. I haven't done a perfect check, but I've been working off the order. We'll see if any differences show up.
Okay, so we go back to the order. Yeah, okay. Right.
So, my lord, we start with the first two categories, audited financial statements and utility bills. And the relevance of this, it was said in submissions, was that it's going to show whether Liberty DMCC was even capable of employing someone at the time. Now, my lord asked where this is pleaded, and the reference that my lord was given was this paragraph 27 of the amended particulars of claim.
Yeah.
That perhaps we should just pull that up again. It's at page 142 of the bundle.
Yeah, paragraph 27. Yeah.
And of course, the closest that this paragraph gets to that proposition is towards the end, where it talks about decanting its existing staff from the premises to the new premises in Liberty DIFC. That was the best we got in terms of the pleading. As my lord noted, that passage of the pleading is admitted. And there was a bit of confusion about that, but just if we turn to page 176, I see it, paragraph 27. We've seen this a few times now. The first sentence is denied. The remainder of the paragraph is admitted, and then it's explained why Mr. Gupta thought that was a good idea.
Yeah.
So there really is nothing on the pleading that supports these series of requests. There was then a suggestion that it's covered by the more general point that he is employed by Liberty DIFC. But my lord, that really is a gateway into all manner of inquiries that aren't pleaded. It's one thing to say that the relationship was carried on in such a way that indicated that he was employed by Liberty DIFC. And we've now had various heads of disclosure going to that issue. It's quite another thing to say that Liberty DMCC was not even capable of being an employer. That suggestion is not pleaded anywhere. And it's really going into the realms of an inquiry that just won't be helpful, and there's likely to be a distraction. And my lord, more than that, because it's also inconsistent with their own alternative case, because there is, of course, a case pleaded by my learned friend that he remained employed by Liberty DMCC. And that case is not just an add-on, it's a substantial amount of work because it involves new claims formulated under a different system of law, different implied duties in the contract and so on, which introduces a significant dimension to the case. I appreciate it's an alternative case, but for there in those circumstances, for there to be an unpleaded allegation that Liberty DMCC was just completely incapable of being an employer to be explored through this disclosure request really illustrates just how peripheral we are at this stage. Now, if we then look at the particular requests, we've got audited financial statements for 4 financial years. I think that was narrowed to 3 in my learned friend's submission.
January 20 to December 22.
Yes, it narrowed to those 3 years. It's still quite unclear to me why 2020 should matter, because the transfer happened in July 2021. So even if we were to have this production, I don't understand why we would be going back to 2020. And the same thing goes for the utility bills. Now, again, we've sought to find out what we can about how these things could be produced if it really is going to be of assistance. I understand that the utility bills are not stored in a way that is straightforward to bring them out. They're in old files that will need to be tracked down and located somewhere. And of course, there's sensitivity about audited financial statements in these proceedings, and there's been confidentiality issues that have been ventilated between the parties already, to which we'll come. But my primary position is that none of this is really going to be helpful, and it's all a fishing expedition in aid of an unpleaded allegation. And there's a sort of creep going on here between request 10 and 12, and now all of these various requests. And there's always a temptation to just incrementally order a little bit more here and a little bit more there. But as a matter of principle, it's not really relevant and not going to be of assistance. We then come to number 3, records of employees. Although we touched on this briefly yesterday, and in fact, employee records. I'm so
just
sorry.
like numbering. The numbering on 487 is different from the numbering in the draft order. This one.
Yes.
Okay.
We touched on employees briefly yesterday, and in fact, in the revised compromise request 10 that was circulated overnight, the reference to records of employees has been carved out of the request. And so we'd rather understood that this was gone. And if one just looks back at that compromise request, perhaps, if my lord has that sheet, the revised wording says it's the second numeral 1 in the previous draft.
Yeah.
The planned or actual transfer of all or any employees employed by Liberty DMCC to DIFC, excluding employment records.
Yeah.
So it's been carved out there. And so we'd rather understood that that was part of the narrowing process that my learned friends had considered overnight. So we're somewhat surprised to hear that it's still being pursued under a different guise.
So what is the substantive difference between this part of the DMCC request, which is B3 of the draft order, and the what's presently been agreed as part of the compromise request 10?
Well, I think it's a good question. I mean, my learned friend said they don't want the HR records. I think that's what was being carved out of the compromise request. But then the description of the records in B3 is much more expansive. We're talking about
Is it substantially wider? As a matter of substance, is it wider?
Well, it's at the very least confusingly cross-cutting, but I think it is substantially wider because we're talking about, well, first of all, we are talking about records. So this is the HR records, presumably, or indeed any other records. And it includes names, roles, reporting lines, termination, and any transfer. So
it's not the whole of the records, though. It's simply the records insofar as showing the names, details, termination, and so on.
Yes. Well,
we got rid of the word including.
Yes. So, but even if we take that out, we're talking about, for instance, why on earth does my learned friend need to have the details, the name and reporting line of an employee of Liberty DMCC that was terminated in February 2021. I mean, it's just not going to be relevant to the case at all. We've already got compromise request 12, which is intended to sweep up this issue of a broader class of transfer from DMCC to DIFC. And in my submission, that ought to be sufficient. And really, this is just another example of unhelpfully cross-cutting requests that we're having to now set side by side and parse the wording in order to identify what else needs to be done. So we don't think that this request 3 is going to be helpful. And then we come to 4.
Just give me a second, can you?
Oh, sorry.
For myself, I'll ask Ms. Ahmed in due course, but not now, but just so you can help me if you can. Looking at compromise request 10, the second part of it, if you read it carefully, it doesn't seem to me that this part of the DMCC request takes it any further at all.
Well, it's the
reporting lines is covered presumably by documents concerning the planned or actual transfer of ordinary employees.
Well, that may be so. I mean, for example, suppose there's an employee who wasn't transferred to Liberty DIFC, but was terminated in early 2021 before DIFC was even incorporated, or shortly afterwards, for unrelated reasons. Well, what 3 appears on its face to require is the production of the file in relation to that employee, who they were reporting to, and the details of their termination, including the reasons for it and so on. I mean, I entirely agree that insofar as relevant, really the formulation of compromise request 10 as reformulated overnight and as thrashed out further this morning really ought to deal with the issue. So it may be that the sorts of hypotheses I'm putting now about little 3 are peripheral, and that my law's right to say that it doesn't add materially to what's in compromise request 10. But in a sense, either way, the outcome is the same.
Yeah, okay. Sorry, I interrupted you. You're taking me to something.
No, not at all. I was just moving on to the last one. And this request has been very substantially redrafted this morning.
Yes.
And so while I've been making other submissions, we've been frantically trying to work out what this would involve. But I'll just take it, and I hope that I've captured what my learned friend said correctly. There was 2 elements to it. So regulatory, the word regulatory is gone.
Because that's covered by financial.
Yes, and so in a sense, all the points I made in relation to that apply equally here.
Yeah.
Then we're left with compliance and licensing, but instead of those words, we've got a more specific request. So for licensing, specifically it said that my learned friend would like the active and valid trade licenses issued by the DMCC Free Zone Authority in the period, I think my learned friend said 1st of January 2020, although that may have been a misstatement. I think it should be 2021.
She said 2020, but probably meant 2021.
That's certainly what's in the order.
All right, okay.
So I don't think she was intending to expand upon what's in the order. including any renewals, modifications, suspensions, and revocations, and so on. So effectively, the trade licenses, and anything ancillary to that showing what went on. And as I understand it, the purpose of this is to deal with the case that DMCC wasn't even an entity capable of operating and employing anyone because it didn't have a trade license to do so.
Yeah.
Now, I've made the points about the relevance of that, but pragmatically and being constructive, we think this is something that we can produce without it being too onerous, and it should really be enough to deal with this new and unpleaded case. And if my learned friend thinks, having seen the production and read the document production statement, that something further is required, then it can be taken up. But given the peripheral nature of this issue, in our submission, that really ought to deal with it. Because I then turn to, sorry.
That covers A of the redrafted 3.
It does. And when I come to B, this is where I say that really A should be enough, because when we get into B, we really are on quite an extravagant fishing expedition into the tax. My learned friend wants the tax returns filed by the company for 2 or 3 years, wants any penalties that have been issued for failure to file tax returns and so on. And it may be that my learned friend hopes this will set up some productive line of cross-examination for Mr. Gupta. I don't know. But really, this is just not necessary when one has to recall that we're concerned here with an issue about whether the claimant's employment was transferred from one entity to another. And documents like unveiling all of the tax returns between quite hostile parties is not necessary for the resolution of that issue, and really not proportionate either. And so we do say that that's just too far.
Right. What did you say about the audited financial statements earlier?
Well, the audited financial statements, I said much the same thing, because of course the audited financial statements are not public, or the financial statements such as they are. I don't know what the status of those financial statements, whether they're audited or not. But again, it's all of the financial information about these companies being dredged up in aid of, it said, an unpleaded case that the company wasn't even active or wasn't capable of employing the claimant, when the claimant himself advances an alternative case, at least, that the company did employ him. And it's common ground, on the pleadings at least, that the company was active. So in my submission, insofar as that really is an issue that warrants explanation, the proper way to deal with it is through the production of the trade licensing documentation, because that's what really shows whether the company was operative and capable of employing someone. And then there'll, of course, be all of the evidence about how the particular employment relationship was conducted, where he spent his time, how his team was distributed, the level of access that they had to various offices, and so on. So venturing further into, the individual water bills that these companies had in every line in their financial statements, it's just not necessary.
Mm-hmm.
Now, there is, of course, a separate request, 13, which we'll come on to, which deals with various financial statements. And it is, or at least was until very recently, common ground that those materials were necessary for a different purpose, to inform the expert's analysis, and should be subject to an appropriate confidentiality regime. And we'll come on to that in further detail in a moment. But
I was wondering whether the financial statements and the tax returns might also be relevant to the experts.
Well, insofar as they are relevant to the experts, they'll be produced
by
under
30,
that issue. And certainly I'll come on to all of this. I've got a lot more to say about this issue, but there are financial statements being disclosed under that issue, and we've said so in evidence. So, but for the purposes of this issue about whether the employment relationship changed, an exploration of the financial affairs of Liberty DMCC will not be helpful and is a fishing expedition.
Right. Is that all you want to say at the moment?
Yes, my lord.
Ms. Ahmed, what do you say in response?
Yes, Your Lordship, I want to pick up on the first point that my learned friend keeps reiterating, and that is it's a fishing expedition in aid of unpleaded allegations of a peripheral issue. Just taking that last point, this isn't a peripheral issue. It is a core issue. It's a threshold issue that the court will have to determine as to who is the correct employee, even before it goes on to determine whether or not there was an oral agreement, whether or what the rights and obligations were under any contract, who was the correct employer, and all of this examination goes towards that. So that's the first point, but it's not a peripheral issue. The second point is my learned friend keeps repeating that it's an unpleaded allegation. Your Lordship, in the DIFC courts, not every document or issue needs to be explicitly pleaded, provided it falls within the scope of the pleaded case and relevant to the resolution of the dispute. And we say the identity of the employer, the assessment of the facts that give rise to how the court might infer the correct employer is, and therefore these documents fall within the scope of that pleaded case. And Your Lordship, just for your reference, the cases that I'm referring to that set that out, the first one is the Gulf Navigation Holding, PJSC, and the proposition there is that the test for disclosure is not determined by the document itself. It's expressly, or whether it's expressly pleaded, but whether or not it may resolve in assist in resolving the issues. So that's the first line of authority. The second one is DNB Bank, ASA, and Gulf Navigation. And again, it's not set out there that every issue needs to be in the pleadings to warrant disclosure. The question is whether or not it's reasonably likely to be material to the matters in dispute. And also the case of Karafi, where Chief Justice, as he was then, Sir John Chadwick, presided over, stating that the DIFC courts emphasised that the disclosure aims to uncover documents that are material to the case, relevant and material, and therefore that definition that's formulated from the rules doesn't necessarily say that it has to be with respect to every pleaded issue, or, putting it differently, that every issue has to be pleaded that forms part of the case. So that's the second point in relation to the lack of pleading point that my learned friend keeps raising. Now, in terms of the fishing expedition, Your Lordship, I've given you my submissions on that earlier. I don't have anything to repeat apart from then taking the specific points that have been made about the request that's been made. The first one that I want to take is the tax returns and why that is relevant. Well, we say, Your Lordship, that under UAE law, any entity that conducts taxable activities with a turnover of a mandatory threshold, and I think from memory it's 375,000 annually, although I wasn't able to check that, but there is a threshold requirement for when VAT returns must be filed, and they must be periodic. I think it's every quarter. What we say is that the absence of VAT filings would indicate whether or not Liberty DMCC was engaging in active business operations or not. It would also demonstrate economic activity in terms of whether or not it was generating revenue, or whether it was not filing any tax returns. And of course, not filing would give an indication that Liberty DMCC was either a dormant entity or that it ceased active operations. And therefore, we say that is why it is relevant. Finally, Your Lordship,
Mr. Trotter says that the licensing information should give you enough on that.
Well, the licensing information will only provide information that the entity is licensed. It doesn't provide any information about any operational activity that might be going on. So, revenue generation, for instance, for payroll activities or office administration and so forth, or any revenue generation that might be going on that would give or infer that this was an operational active entity. Finally, Your Lordship, my learned friend also keeps saying that, keeps submitting that, well, there is an alternative case that's being put forward by the claimant that the DMCC entity is an employer, and therefore what I understand the submission to mean is that we can't have our cake and eat it. But Your Lordship, that is an alternative case, and that doesn't necessarily, and it's a fallback position or a contingency argument. It doesn't necessarily mean that it's our primary case, and these requests are being made with respect to our primary case, and so we say that there's no merit in that particular argument being advanced. And so, Your Lordship, that's what I say about those sort of general points that are being made. In terms of the points that were discussed about the wording of 1B3, I do take the point that's being made by my learned friend. However, and insofar that there might be some overlap with compromise request 10.2, as has been formulated.
Hang on a second, 1B3. Oh, yeah. Okay.
1B3, yes. Insofar as showing their names, roles, well, let me deal with 1B3, details of any transfer. Well, that it's right to say, and I think it's fair to say that that does compromise, or rather form part of compromise request 10.
Yeah. In
terms of the names, roles and reporting lines, that's just simply an extension of what's being requested in compromise 10, and if Your Lordship considers that compromise 10 as formulated covers it, then we see that point and that can go. Your Lordship, having reconsidered 1B3(2), details of any termination as an employee of Liberty DMCC, again, it's a fair point that is being made, and we're happy to delete that and strike that from that particular request.
So would the whole of 1B3 come out then?
It would come out only insofar as the names, roles and reporting lines would then form part of compromise request 10.
But I'm not going to revisit compromise request 10. Nor am I going to give some interim ruling as a matter of construction as to what that covers. You tell me, as far as I thought I understood your submission to be the recognition that 1B3.
2 can go.
2 of what?
1B3(2).
1B3(1).
Well, I think 1B3(1) should remain because it's quite important, we say, to understand which employees have transferred.
Well,
and they're all.
It's dealt with in compromise request 10, isn't it? Planned or actual transfer of all and any employees.
It doesn't say that the defendants would have to provide the names, roles and reporting lines, but if it's being said that that is implicit within compromise request 12, that they will provide the names, roles and reporting lines, and then I'm content with that.
Well, I'm not going to rule about whether it's implicit or not, but I think it seems to me that it overlaps sufficiently to delete it from 1B3. And what about 1B3(3)? That goes?
That goes, yes. We recognise that that does.
So the whole of 1B3 goes. If there's a gap when you get stuff, you can ask for it.
Yes, we're content with that.
Right, that's progress. Where do we go next? So, but you, as you say, basically, as regards the rest, you need the financial information. Is that right?
Yes, for the reasons that.
That's right. That's request 1. And sorry, I was just That's both the audited financial statements and the tax return submitted during that period.
So it's 1B, Roman numeral 1 and 2 of the draft order at page 13. 1B, Roman numeral 3 goes, and then 1B, Roman numeral 4, as articulated this morning.
As redrafted this morning.
Yes.
As to which Mr. Trotter is happy enough to give you the licensing stuff, but objects to the tax returns.
Yes.
Yep.
Yeah.
Okay. Oh. Subject to anything. Now you want to come back on Mr. Trotter. I'm not inviting you to do so unless you particularly felt you haven't covered something.
No, my lord, I think I've addressed you on the relevant matters.
I think it is relevant, as I read the case at the moment, for there to be some flesh on the transfer by conduct application argument, and some flesh needs to be given to what was DMCC's financial strength and abilities in the way, if it could be done without too much documentation, all the better. But it seems to me that there ought to be possible to produce the audited financial statements with redactions if necessary, and ditto the tax returns with redactions if necessary. What we want are headline figures, in the first instance at least. And so what I would order, basically make an order in terms of 1.1, sorry, just the numbering has gone so bizarre. 1B1, covering the period January 2020 to end of December 2022.
Sorry, did my lord say January 2021?
Have I got that wrong? January 2020 to December 2022. Is that wrong? Is that?
I think the period being contended for, which one finds in Roman numeral 4 of the original draft order as sought by my learned friend.
I was looking at
January
1B. Oh, sorry, excuse me. I was looking at
1B1.
1B1.
Yes, which is the 1st of January.
Yes, well, I mean, as originally drafted, of course, that was from 2018 onwards.
Yeah.
There was some movement in that, and I had understood it to be 2021 because the transfer is alleged to have happened in July 2021. So the question is whether there was material activity going on thereafter.
There can't be any harm in that, can there, Ms. Ahmed?
Well, the reason why we've said 1st of January 2020 with the audited financial statements and the utility bills is because we could compare then the pre-transition period or the pre-incorporation period. And when I say incorporation, I'm talking about Liberty DIFC incorporation, which was on the 18th of February 2021, with the sort of post-incorporation period, which is why we've provided that date range for both the utility bills and the financial statements. And the utility bills is to show any sort of decline in operations.
Well, that seems to me to raise a different point of relevance to what you've been submitting so far. And I think for the moment, we'll make it 2021, January 2021. Because on the basis of your justification for it, to show that, to see whether or not DMCC was a viable company, comparison with the previous year doesn't necessarily is not necessarily relevant or material. So I'll make an order in terms of one, doing it by reference to the draft on page 13, 1B1, limited to the period of 1st January 2021 to 31st December 2022. I will make an order in terms of 1B2 for the same period. As regards 1B4, I will make an order in terms of the draft that was dictated, and I think everyone's got a note of that, which is in two parts. Copies of DMCC's A, active and valid trade licenses issued by DMCC Free Zone Authority for the period from January 2021, 1st January 2021 to 31st December 2022, including any annual renewals and/or modification and/or suspension and/or revocation. And B, tax returns submitted by DMCC to UAE Federal Tax Authority between 1st December 2020, 1st January 2021 to 31st December 2022, including any penalties issued for failing to file such returns. I'm conscious there's 2 points there. There is, I think it overlaps with a confidentiality undertaking, which has got to be considered. And secondly, whether in the first instance, at least, there can be scope for redactions. But I don't think an order needs to be made about that, in the sense that if it is sought to redact things, that can be done in the first instance. If there's a complaint about it, then that can be resolved.
Yes, Lord.
I'm conscious redactions wasn't raised by me in the course of your submissions, but it seems to me it's always a possibility in this sort of situation.
Yes, and we certainly welcome that in relation to redactions. We'll come on to the confidentiality regime in a little bit more detail in a moment, but in broad terms, the reason why that's been proposed is that the very purpose of the disclosure of certain financial information means that there's just a certain amount of sensitive material that cannot be redacted, because it's exactly what parties need. And so certainly there's a degree. Yes. And so we can come on to that again in more detail, but I think we would say that in any event, these financial documents ought to go into the confidentiality ring, or at least it ought to be open to us to look at them, decide whether they warrant protection, and to designate them if necessary. And if there's a dispute about that, then it can be sorted out. But it may be that there are still confidentiality issues. I just don't know, because I haven't seen the documents yet. We haven't even looked for them.
Yeah, okay. Right, that's DMCC. Are we going back to
Schedule A?
Schedule A. Yeah.
So page
22, is it?
Yes, but now we're dealing with.
So we've done 12, haven't we?
Yes, so repeated original request 13. These are the performance and financial documents. And we say these are required for the expert report.
Oh, yes.
And your Lordship, this request was first made on the 20th of August 2024, when the original RTP was sent to the defendants. And Your Lordship, if I can invite you to turn up Sing 2, page 41, paragraph 44.
Sing 2. What page is Sing 2?
Page 44, 41. And it's paragraph 44.
Yeah.
And you were taken to this yesterday as part of a criticism that the claimant hadn't completed its review. But the point here is that on the 9th of December, so just bearing in mind that this is now nearly 3 months from when the RTP was originally served, the claimant wrote and said that in that period of time, there was a review going on, and that it had become obvious that the financial records demonstrating how EBITDA was calculated during the relevant period hadn't been disclosed. And to that extent, Your Lordship, the claimant wrote to the defendants at that time. And just in terms of the request, you have the request there, Your Lordship, and no doubt my learned friend will dissect it, but you have the request there, and we say all of those documents are relevant, and they're designed really to capture, if I can just perhaps summarize it, performance reports, which are monthly and quarterly performance reports, including EBITDA growth and financial performance of the business units, and such as, and these are sort of quite specifically defined because the claimant is aware that these exist, because during the currency of his employment, he was given and provided with, for instance, MPA, monthly business reports by the financial controllers and the CFOs of each business unit, and quarterly reports and budget documents.
Mm-hmm.
And that's it, let's say 3A, and we see the custodians there, and it's the claimant's instructions that those were the individuals, and I'm looking at now 2A, B, C, and D, those were the individuals that were dealing with these reports and were responsible for these reports. And so 13.1, that's the MPA business reports. 2 are the relevant emails. Now, the claimant's instructions are that the reason why these are relevant is because they're related to performance by him in particular. And because and the claimant was overseeing various business units in Europe and Australia, and therefore the claimant requires those internal emails of those business units that he was responsible for. Moving on to, and I've already discussed 2A to D.
Why do we need the, sorry, it's my fault, I'm sure. Why do we need the emails rather than, and the proposal by the defendants, as I understand it, is simply to say reasonably available records of the revenue of the business units from certain dates.
My Lord, the reason why there is a concern over the reformulation of the defendant is because we say that that's narrow. EBITDA isn't simply a reflection of revenue. EBITDA would require, or rather the LTIP entitlement depends on EBITDA growth, which depends in turn on operational contributions and not just revenue figures. And so the expert can't just look at revenue to understand whether or not there has been, and assess whether or not there has been EBITDA growth. That would require a broader performance-related assessment to establish, firstly, whether metrics tied to the LTP were met, but also, and more critically, the EBITDA growth by reference to performance targets, operational improvements. And so revenue is just a tiny part of the EBITDA assessment. There is more to the EBITDA assessment, and therefore we say that that revenue reformulation is very narrow. And so, Your Lordship, that's the issue with the defendant's reformulation. And therefore, the claimant is aware of the existence of these documents, the performance notes, the MPA reports, the monthly and quarterly reports, because he was sent them by the defendants. And coming back to your question as to why the emails are relevant, because he was sent them these reports by email. And also, as I understand, is that the emails would then set out basically a summary of how the claimant had performed, or rather, putting it differently, how the business units in Australia and Europe had performed, and hence why that request is being made about the internal emails. Paragraph 4 of the request, documents or reports from any function within the Liberty Steel Group that are relevant in assessing the claimant's performance and growth metrics. Your Lordship, when we say any function, of course, it would be the accounts team, the finance team. There were press releases as well made about the performance of the claimant, and therefore that would be a function within Liberty Steel Group, or rather, putting it differently, a department that would provide some understanding of how the claimant had performed. And so that is why that request is being made there. 5, any internal documents concerning calculations or assessments performed to determine the claimant's entitlement under LTIP, and 6, financial statements and accounts for the business units covering the years 2019 and 2020 that reflect EBITDA and overall financial performance. They should include quarterly business area review, and these are specific documents, bar the bar documents or bar review documents that the claimant is aware of that exist from Q1 2019 to Q4 2022 for the business units. Now, taking that together, Your Lordship, there is in disclosure a table setting out the performance by reference to EBITDA. I don't think it's in the bundle, so I can't take you to it, but it's certainly been disclosed. Now, that provides a table of figures relating to EBITDA growth and the claimant's performance over a period of time for business units that the claimant was responsible for. What the claimant doesn't have, as I understand, are the underlying figures supporting that table, and the expert has requested that specifically. And so the request at 5 and 6 is designed to cover the underlying material to that table. 7 is metadata, but that would be quite easy if we were to get the native formats of the documents. We'd be able to extract the metadata from them. And the board
in this context, what is the metadata?
The metadata would be when the document was produced and who produced it.
But do you need that? You only need that if you have a suspicion that something's being created later.
Indeed, but as I understand from the
platform, is there any suspicion?
Not at this stage, because we don't have the documents. But if, for instance, the documents were to be provided in native format, then we would be able to extract that metadata in any event. And so I suppose the wording should read electronic documents to be provided in their native format.
Again, is that normal?
Well, Your Lordship, it is normal. The platforms that are being used are quite well advanced, and so there has been a number of requests, as I understand, from the defendants for native emails, for instance, and native documents. And if one puts that into one of the kind of platforms that are being used for disclosure, then that information can be extracted. And so
I just haven't come across people asking for metadata in the disclosure.
Well, it may be that we can change that wording, and rather than metadata, it should be native.
I'm not worried about the wording. I'm worried about the concept. Not worried about it. I'm surprised that we go straight from. Well, we jump out. I can understand it if there's some concern about authenticity.
Your Lordship, at this stage, we don't have a concern because we don't have the documents. Obviously, once we've got the documents, the claimant can review them, and if he has some concerns, then perhaps we can pursue that at that point. And
wouldn't it be best to take that in stages?
Yes, Your Lordship, I do.
Leave out 7 for the moment.
Yes, and to the board meetings from the boards of the various entities there that the claimant was responsible for, and those board meetings would then shed light about the performance of the units, the business units that the claimant was responsible for, as well as the claimant's own performance themselves.
Is that not going quite wide?
Your Lordship, if we leave it to documents and communications relating to business reports and performances, so let's say 1 to 6, leave 7 out, I'm happy to leave the request there. And so again, Your Lordship, I think the point is this, that the revenue alone can't demonstrate whether the claimant's termination was motivated, again, by an intent to avoid LTIP payouts. And so, Your Lordship, we say that the reformulation of the defendants is very narrow and doesn't really cover the metric that we say was applied to the claimant's performance, and that was EBITDA. And for the purposes of the expert report, the expert would like also to see these documents, and we know that they exist because the claimant was aware of them. We know that he was sent these documents, and they are in the possession, custody and control of the defendants. Now, as I understand from from Mr. Swangard's evidence, that there are in the region of about 250 documents around the sort of financial nature that are that the defendants have that they want to disclose. Now, it's not clear to us whether those 250 documents are responsive to the requests that have been made here. That's unclear. But putting that to one side, Your Lordship, there has been reference made to confidentiality issues here. And Your Lordship, if I can perhaps take this now. On the 15th of November, the first tranche of disclosure was given. And Your Lordship, if I can take you to page 460 of the bundle. And you'll recall I took you to this letter yesterday. And the point that was being made there was that this letter was sent at around 4:30 p.m. when disclosure was supposed to be given at 4 o'clock.
Yeah, that's, yeah.
And what it said is that the claimant, or rather the defendant, had documents to produce which were highly confidential, commercially sensitive, and set out the nature or the categories of those types of documents at 4A to D. And then paragraph 4A to C provided for the sorts of provisions that are usual when it comes to commercially sensitive financial documents. And in response, to avoid holding up...
I see it doesn't allow the documents to be shown to the judge.
Yes, that's right. Is
that deliberate?
Your Lordship, I'm not entirely sure. Mr. Trotter is probably the best person to respond to that, but it was envisaged from this letter that those documents would be produced, and if there was any contention around the confidentiality of those documents, then that would be a matter to put in front of the judge. Although, Your Lordship, if given that you're the trial judge, it probably wouldn't be appropriate to go in front of you, but rather another judge. But at the moment, that the discussions around what would happen if there was a dispute around the confidentiality of a document really hasn't been aired at this stage. What is in contention is, firstly, whether or not confidentiality is appropriate, and we have said yes if it's simple, and we say that in our response at page 464. And we envisaged that the confidentiality undertakings that were going to be requested would be simple. However, once we'd provided our agreement to provide confidentiality undertakings, we had nothing from the defendants until the 24th of December after the application was filed and served. And in that context, Your Lordship, if I could invite you to turn up 525. And what we received was a letter attaching a document. Well, first of all, paragraph 2.
525 begins at paragraph 6.
I beg your pardon?
525 begins at paragraph 6. So
it's the page before 524. Yes.
Right.
So on the 24th of December, the claimant's told at paragraph 2 that there would be that there is an intention to disclose a further tranche of documents containing to around 250 documents, and those documents are comprised primarily of financial information concerning the defendants. Now, pausing there a second, when on the 15th of November, the claimants eagerly agreed to the confidentiality undertakings, it was envisaged from the letter that had been written by DCO that that was because those tranche of documents would include the financial documents, but obviously they didn't. Then in terms of going over the page, well, they referred to a draft consent order with respect to the confidentiality regime that they propose. And at 525, they ask that the claimant confirms by Friday, the 27th of December, whether or not the draft consent order is agreed. Now, again, pausing there a second in terms of the timeline, we served this request on the 20th of August. Nothing is heard apart from the objections on the 27th of September, which were served by the defendants.
I understand the nature of the grievance and so on. I'm concerned at the moment with what order to make.
Yes.
Now, not
yes,
the history of who did wrong by what time.
I'll move on then. Your Lordship, you have page 4, I beg your pardon, 526 is the confidentiality order that's been proposed by the defendants. And what we say, well, primarily, first and foremost, there is no application before you from the defendants of an order of this nature. That's the first point. They simply said confidentiality undertakings, which we agreed to by reference to the earlier letter of the 15th of November.
Right.
The second point is with regards to the order that they are seeking, we say that these exceed what is ordinarily required by reference to confidentiality undertakings in litigation. And what we say is that it introduces an unnecessary burden. And quite frankly, we say it's unreasonable and disproportionate, and it doesn't serve the legitimate needs of the parties. And the reason why we say that is if one looks at, let's say, page 527, now the definition of confidential information is quite wide. Well, it's overly broad, very wide, and it includes not only general financial business information, but also the discretion for the defendant to determine what documents are confidential and classify the documents as confidential without sufficient justification. So that's the first point in terms of the definition of confidential information.
Yeah.
And we say standard confidentiality orders typically...
Before you go any further, what are you expecting me to do at the end of this discussion?
Well, Your Lordship, we say that if there is a confidentiality concern, then the documents should be disclosed. The defendants should inform us that there is a concern with confidentiality and these documents they require to be confidential. The claimant then takes a view as to whether or not it meets the threshold of confidentiality, the usual confidentiality.
So, how are you asking me under some application to address, refine, vary, or
no,
whatever
I'm not.
in terms of the confidentiality agreement?
No, I'm not.
So why am I going to the details of it then?
In which case, I'll leave my submissions there, Your Lordship. We are, on behalf of the claimant's position is that in terms of any sort of redactions or any confidentiality that is being sought by the defendants, then the claimant is happy to consider that and provide any undertakings that he considers are reasonable and proportionate to address the legitimate needs of the defendant for confidentiality.
Right.
And in Your Lordship, as I've said, there is no application before you. So maybe I'll pause there and allow Mr. Trotter to submit as to why, or rather the extent to which he is seeking any confidentiality order. I mean, what we say at the moment is that this consent order isn't agreed. It's over the top. It's not proportionate. It's disproportionate. It's overly broad.
So you are asking me to do something about it?
No, I'm not. I'm not.
You're not. Okay.
I'll stop. I'll stop here then, and I'll wait to see what Mr. Trotter says.
I'm getting confused. You tell me that I'm not, and then you start taking me to the terms of it and saying how appalling it is, and then I ask you again, and then you say you're not asking me.
No,
to do
I'm not.
anything.
What I will do is I'll pause there in my submissions, Your Lordship, and I'll allow Mr. Trotter. Well, it would be helpful to understand what Mr. Trotter is seeking in terms of any confidentiality provisions.
I think you've got. Do you have your answer in the draft order?
Well, we're not agreeing to that, Your Lordship, and if the defendants make an application, then we'll respond to it accordingly. At the moment, there is no application before you in the terms that are being sought in this consent order.
Okay.
I mean, the point is, Your Lordship, that this is a commercial trial. It's litigation. The claimant understands that some documents may be sensitive, they may be confidential, and therefore the claimant will take a position as and when those documents are disclosed.
Right. Mr. Trotter.
My lord, well, I propose to deal with relevance first and then to deal with the confidentiality point. But given that it's been the topic of such heated submissions, I'll just say broadly what our position is. I don't want to trawl through the correspondence again. I expect my lord doesn't want to either. But an agreement in broad terms was reached about confidentiality, subject to embodiment in an order. And we had understood that this would be rather uncontroversial. And there's been much histrionics about the nature of the order and so on. But in fact, it's a confidentiality ring order of a kind that my lord will have seen many times before. It's not a complicated order. We've proposed it for the very out.
I haven't seen many of them actually. But I thought all litigation has an implied confidentiality, not to use the documents for the purpose of any other purpose.
Yes, my lord. I'll need to develop all of this in a little bit more detail. But the thrust of the object of the order, as was the object of the original proposal that was agreed in correspondence, was just to ensure that confidential material is not suddenly deployed in a public hearing or referred to in some way that has the consequence of lifting that restriction on collateral use and confidentiality without proper notice. So the only purpose of it is to ensure that, first of all, that the documents are kept confidential and to make sure that they're only distributed as far as really is necessary. And second, to make sure that they're not suddenly made public without an opportunity for an application to be made. And that's always the intention of these confidentiality ring orders, and this one's no different. I'll come on to it, as I say, in a bit more detail. It hasn't been launched at the last minute, as my learned friend suggests. Our position in relation to these documents from the very outset has been that they will be disclosed subject to a confidentiality regime. And in fact, as I'll show your lordship, my learned friend's position has been the same in relation to some of their documents. And so we had understood that this would be a circumstance where the parties would engage about the terms of the confidentiality regime, and we really wouldn't have to trouble your lordship with the question of principle. We received some encouragement in Sing 3 when there was finally some engagement with the terms of the order, and we've written to the other side to try and address those concerns. So I do regret that we're back in this position now, but there we are. Now, can I start then with the relevance of the request? And at its core, this category of production is designed to assist the parties in calculating the growth of the relevant business units. And there's been quite a lot of confusion and a fair bit of shifting about the rationale for this request. So I'd like to just go right back to the start and look at the 5th of September letter, which one finds quoted in the particulars of claim at 139 of the bundle.
Yeah.
So this is where it all begins for this issue. At the very bottom of that page, we see the reference to LTIP, and really this is the provision on which my learned friend's entire case hangs. 100% growth, brackets, metrics TBA, to achieve LTIP, fully vested at end of 3-year period.
Yeah.
Now, there are 3 issues broadly between the parties that arise from this. First, there is a question about whether any metrics were actually agreed.
Yeah.
And if so, what they were. Second, there's an issue regarding the final line about whether the long-term incentive plan, in accordance with its name, invested at the end of the long term. And third, there's a question about whether, if it was agreed, then it accrued. The question that depends on whether the growth target was met.
Yeah.
So those are the 3 issues, and it's the third of those that this disclosure is designed to tackle. And just to elaborate on that a little bit, if we then look at paragraph or page 147 of the bundle, paragraph 37.
Give me 1 second. I'm just rereading the term. So it's 10 million per annum based on performance of a 3-year period. And
those are the words they use, yes.
Yeah. So how does it work?
And then we have 100% growth target, metrics TBA, to achieve that payout and fully vested in the end of 3-year period. So the way
you have to reach that target, do you, before you get anything?
Well, there's obviously a dispute about this. We say, first of all, it's really too uncertain to amount to an agreement at all because it's horribly unclear exactly what the target is, the threshold that's to be met. It's all subject to contract. My learned friend says that if the 100% growth target was met by growth in she says this should be read as referring to the growth in the EBITDA of the business units for which the claimant was responsible. So one has to imply those words into this phrase.
Yeah.
And then we say, then there's a dispute about the final line. We say that LTIP, the long-term incentive plan, the purpose of it is to make sure that to incentivize someone to stay long-term. So best at the end of the long-term 3-year period.
Yeah.
My learned friend has a different interpretation. She says that there is an obligation on the defendants, come what may, to employ the defendant for a minimum term of 3 years.
To give the opportunity of the growth target to be achieved.
Yes.
Yeah. Okay.
So those are, in broad terms, the competing cases. As I say, there's 3 issues that arise from that, and maybe we don't really need to go through the pleadings. Although I may just show my lord the parts where the expert issues arise, because that's where this disclosure fits in. So if we just look at page 148. At paragraph 37.4. So here we're talking about the first point, what is the metrics? The claimant's case is that his experience is that growth in EBITDA provided the standard measure for the purposes of incentive plans in the industry.
Yeah.
And so his case is, well, the words EBITDA don't appear anywhere in the letter, but this was all totally standard in the business, and so it referred to EBITDA. And that we don't need to go to it, but that's denied in the defence. So that's where that's where that issue arises. The second issue I mentioned was the minimum vesting.
Yes, the 3-year point.
3-year period. This one arises from our defence. If we look at page 181.
Yeah.
And paragraph 37.5.4 in the middle of the page. My lord sees the red text, which has been introduced by amendment. And so our position is, if this was agreed at all, then it was a long-term incentive plan that only invests at the end of the long term.
Without any obligation to keep the employee for that period.
Yes, that's right. The incentive is on the employee who's being offered the incentive. There's no sort of obligation to keep them employed for that period. And if that's a matter of construction, but also in accordance with industry practice. So that's the second industry practice question.
Mm-hmm.
And then the third issue I mentioned was accrual. And if we go back to the amended particulars claim at page 152,
yeah,
paragraph 57.1,
yeah,
we have there the claimant's plea that he achieved the necessary growth target,
yeah,
and accordingly the LTIP fell due.
yeah.
And then for completeness, if we just look at the defence, page 187 of the bundle.
Yeah.
At 55.2.1 and 55.2.2.
Yeah.
They're over the 3-year period. The growth in revenue was less than 50%. And so one sees that's where the factual issue emerges about what was the growth. And that's just a question of the figures. So it's quite a different expert evidence issue. Now, my lord made an order.
Sorry, hang on a second. That is an allegation by you about the growth, but it doesn't quite match the claimant's EBITDA case, does it?
No, that's true. The metrics are different. But it was...
So although you say that the relevant issue is growth from the business units, the claimant says that's too narrow a focus. You've got to look at EBITDA.
Well, yes, my lord. I accept that there is an issue about growth, and then there is a dispute between us about how that growth is to be measured. Is it growth in revenue alone or a growth in EBITDA?
Yeah. Okay.
Now, my lord made orders for expert evidence on these issues, which is at page 286 of the bundle.
286. Yeah.
Paragraph 12 of that order.
Yeah.
And here we have, these are the 3 issues that I've just outlined. So A, industry standard practice for evaluating the long-term incentive plan, whether EBITDA is typically used. So that's the metrics issue. So it's a question of market practice rather than a question of fact in this case. 2, industry standard practice in relation to vesting. That's the 3-year point.
3-year point, yeah.
And then C, the quantification of any LTIP that, if found payable, would be due. And really, my lord might remember there was a bit of drafting on the hoof at the restored CMC here, but
I don't understand C.
Yes, well, it was.
I thought the point of the clause, whatever, at least on the claimant's case, was that if you achieve your 100% increase in whatever, then you get to a full 10 million a year.
Yes, exactly. It's an all or nothing provision, so it's no question about calculating bits and pieces. But in fairness to my learned friend, the CMC started off with one issue, and then there was a bit of drafting from everyone piling in, and this is where we ended up. But the thrust, the purpose of this provision, as we understand it, and I think it was common ground at the CMC, was it's to get an expert to help with the figures, to look at what the growth was, to see whether it's triggered or not.
Yeah.
And although this is listed under strictly a mining and steel industry expert, there's, well, one hopes that one can find someone in the mining and steel industry that can help with this as well. But anyway, there we are. That's where we've ended up.
Right.
So So
there's nothing in this order though that tells you that the expert should work out the EBITDA. Is that right?
No, not expressly. I think the basis on which the parties are proceeding is that, loosely speaking, in order to quantify the LTIP that's payable, one needs to work out the growth. And so really what the expert needs to do is to help work out what the growth is.
Yeah, okay.
In order to determine whether it's payable or not.
Without wanting to raise a new issue for discussion now, should there be some discussion between you with a view to a agreed redrafting of 12C?
I think that would be helpful because my Lord might remember I said the same thing at the last CMC, but I'm concerned about ships passing in the night a bit with this expert evidence, and we do need to make sure that it's useful to your lordship at trial.
Perhaps you can have a word with Mr. Ahmed at some stage and see whether you can agree something.
We'll see what we can do.
Okay. Anyway, where are we? Where are we going?
So we've been through the pleadings in the order, but there's 2 points I want to make at this juncture. Yeah. The first is that the disclosure of the financial information will inform the growth calculations. What it doesn't do is assist your lordship at all in understanding what the standard market practice is. Because issues A and B, the expert will be talking about their experience of the market in general, what metrics are used in general, and how vesting mechanisms work in general. But the disclosure won't help with that. The second point is that the growth calculations that the expert will be dealing with are all about the figures. So my learned friend's case is that the LTIP was hard-edged and turned on the numbers. If he hit the threshold, he earned it. If he didn't, he didn't. There's no case for my learned friend that there's some broader discretion or broader soft metric about his performance in some more general sense.
Yeah.
Now,
but there is a case, though, isn't there, that if you're looking at growth in EBITDA, you don't. There's more than one way to skin a cat. You skin cats? No.
Yes, that's absolutely right, my lord. And in fact, it's one of the reasons we say that it's not a certain provision, but that's not an argument for today.
Yeah.
And there is, of course, a risk that the experts will take different approaches to how they calculate EBITDA, for example. We'll just have to deal with that with the experts, and something that will throw up the uncertainty about the whole situation. But in order to deal with this numerical exercise, the proposal that we've made is the one that my lord quoted earlier, the reasonably available records of the revenue of the business units within the relevant time period. Now, my learned friend will say, as my lord's picked up, revenue is not, it is too confined. We accept that, but the document, in practice, the exercise that's been done will go broader than just revenue, and I'll come to that in more detail in a moment. Now, by contrast, we see my learned friend's formulation, which if we just go back to the table again.
Yeah.
Bottom of 22 onto 23. We have a very elaborate and specific group of documents that are being requested, including various internal emails. At one stage, there's a request for Mr. Gupta's podcasts over the course of 3 years. And what one would have expected at some stage is to see an itemized justification for each of these requests. My learned friend said that these requests were made in August, which is right. But we see from the columns of this table there was no itemized justification then, nor was there one in support of the application, nor was there one in Sing 3 in reply, or even in my learned friend's skeleton argument. Now, we heard various points made in oral submissions today from the bar table. We were told that there's some table which is not in the bundle, which makes certain of the information necessary. we were told that there are requests from the expert for particular forms of information, but none of that has ever been put in evidence. We've never had a chance to respond to those points. But if I'm going to deal with the justification that has been given in my learned friend's skeleton argument, because it's a very full explanation as part of the 67-page skeleton and annex that was produced. It's a page. Oh, again, I'm sorry, this doesn't have internal page numbering. I think my lord has it in hard copy.
Give me paragraph numbers.
It starts at 72.1.
Okay, I've got it. Well, I've got 72.
70, yes, 72 is at the bottom of the page, and
it doesn't have a point one. You say 72.1?
Yes, we're in the annex, my lord. The one that's headed Exhibit 3 or Section 3.
Hang on. Annex to payment skeleton.
Yes.
72.1. Okay, yeah.
So I'll take these one by one. So 72.1, it said connection to the expert evidence. If we just jump down to the fourth line, the documents sought, including performance reports, internal communication, financial metrics, so that's some of the points in the list that we saw, are essential for the expert's analysis of the claimant's contributions to business unit performance and whether they are consistent with industry standards.
Yeah.
So this is the point I was making earlier, that this disclosure will not assist the expert and it will not assist your lordship in establishing what the industry standard is for LTIP practices. That's just a question of what goes on in the industry. And in a sense, this fuels my concern about the potential breadth and misfiring of the expert evidence. But again, we can pick that up separately. 72.2 is a new justification. Disputes over the agreement. The defendants argue that the financial metrics governing the LTIP agreement were never agreed upon and that there was ambiguity or uncertainty. To resolve this, we'll need contemporaneous communication. So again, this is justifying the various emails that like. But of course, and we've been over this many times now, but as far as there's a dispute about the terms of his employment and what was agreed, that will have been swept up by request 2A, as with a great many of the other requests we dealt with yesterday.
Yeah.
So we don't need disclosure of financial documentation to work out what was agreed. That will be dealt with by that issue. 72.3 of performance evaluations. And this is addressing whether the claimant met or exceeded the operational metrics expected of him. Well, if there were interim performance evaluations, as I said before, there's no question about whether the LTIP was triggered by generally whether he was doing a good job. It's all about the growth of the business. And so that will be revealed by the data. 72.4. And finally, at 72.4, we arrive at the real point. This is the quantification of LTIP entitlements. The expert will also assess the quantification of the LTIP entitlements if found payable. Again, the wording of that concerns me a bit, but anyhow.
I'm not quite sure. That raises the same question as we raised about the third part of the order.
It does. It does, my lord. But
I thought the whole claimant's case was all or nothing.
Yes, well, I'd rather understood that as well. But if we can perhaps come back to that.
Right.
The next sentence is the justification. So the financial statements, growth metrics, and reports from the business units are necessary to quantify any LTIP-related damages accurately. Now, read charitably, I think what's being said there is that the financial statements and so on will reveal the growth that's necessary to ascertain whether it grew sufficiently as a matter of EBITDA or revenue, as the case may be, in order to trigger that entitlement.
Yeah.
But we see what the documents are that are necessary, and perhaps unsurprisingly, they are the financial statements mainly. I'm not sure what's meant by the growth metrics as a category of documents, and reports from the business units. Well, we see the sense in that. Now, that's what's really required for the real purpose of this exercise. And at this point, we've travelled some distance from the expansive request that was listed in request 13. But we have made the inquiries that we said we would make back in September as regards the reasonably available records that will allow the experts.
Can you hold on a second?
Yes,
I just want to reread one thing. Yeah, sorry. Yeah, carry on.
Not at all. So perhaps while we're here, just 72.5, the reference to the metadata, there was a bit of an exchange with my learned friend about that. And we can see what the purpose of this is, to ensure the integrity and authenticity of the disclosure. And of course, that's really the only circumstance in which metadata is useful, if there's some suggestion that the documents are not genuine. As far as I can tell, there's no suggestion of that kind, at least not at the moment, and at least in relation to these documents. Now, so we see for the core purpose, it's financial statements and reports from the business units. Now, our proposal was reasonably available business records because, of course, when we made the proposal in September, we hadn't yet made the inquiries and we didn't yet know what could most usefully be given to the expert in order to help them measure the growth. But we've now made those inquiries. Mr. Swangard explains where we've got to. It's page 89 of the bundle.
Not in my bundle.
89.
What paragraph of Mr. Swangard?
Oh, I see. Does my lord have that separately?
I think so.
It's at paragraph 77.
As set out above?
Yes.
Yeah, okay.
And it's the second sentence. So we're here describing the tranche that is ready to go. And it's internal managed reports, weekly cash flow reports, formal financial statements, which is what the claimant has said that they need in their skeleton argument, and emails containing relevant financial data, weekly supplier status, and deal sheet updates. So that information has been collated and is ready to be disclosed. It is broader than what we saw in my learned friend's skeleton argument a moment ago, than is really required for the resolution of this issue about growth. Now, the sensible course is, and has always been, for the claimant to review the financial documents that the defendants have identified and disclosed. Now, if in consultation with his expert, he thinks that further material is required, then he can make an appropriately targeted request. And if the expert has a request, rather than them being ventilated for the first time at this hearing, then they can be made in a considered way. It's perfectly sensible for our clients, who are the best positioned to interrogate their own financial records, to make the inquiries through the searches that have been done, rather than for my learned friend from outside the business to fish out a shopping list of records that he thinks will be useful, which is what was effectively done in original request 13. And that was always sensible, but it's especially sensible at this juncture. We find it very surprising that my learned friend will be pressing for the original request, which was made way back in August, now, shortly before our documents are about to be disclosed. If my learned friend had really thought in September when we made our objections, no, that just will not do, we're absolutely certain, and our expert definitely needs this list of material, then the appropriate time to bring this dispute to a head was then. But now that the material is ready to go, the appropriate approach is for my learned friend to review that material and to make any further requests that might be required.
Mm-hmm.
And my lord, we've said in the skeleton argument and in evidence, we also have concerns about the motivations more generally for this request. I'm not going to elaborate on that now, but my lord remembers on the last occasion the sort of correspondence we were getting with wide-ranging requests for financial information of various kinds in aid of some threatened, unarticulated application. Now, that application has never come, but in the circumstances, there's all the more reason to be cautious about the nature of the requests that are being made. So that's the relevance issue. The next point is confidentiality.
Right.
I
mean, should I just hear from Ms. Ahmed first about the relevance point and the idea, the basic proposal that you subject to confidentiality, which may overlap with this, but that the claimant sees what you give him, and then comes back for more if what was given is not enough.
Yeah, I'm perfectly happy with that, my lord, if that would assist.
Ms. Ahmed, would that be, what's the problem with that? Are you talking? You're muted, I think.
My apologies, Your Lordship. Sorry, yes, I was talking. My apologies. The concern with that is that the claimant has identified specific categories of documents that he is aware that exist that go to this point of calculation of LTRIP. And so this is why we say that the concern with what my learned friend is proposing is that it may not cover everything that the claimant knows that exists, and therefore we get into a further round of making requests and then further delay in trying to agree those requests and so forth. And I think that's really the concern. Firstly,
what is set out in paragraph 77 of Mr. What his name is quite wide. Internal management reports, weekly cash flow reports, formal financial statements and emails containing relevant financial data, weekly supplier status reports, and deal sheet updates. It's quite extensive, isn't it? I mean, the proof of the pudding in the eating, but on the face of it, it looks quite extensive.
It does look extensive, but it's still quite a broad sort of definition of documents, the broad category of documents, whereas what we have provided, Your Lordship, are details of specific documents that the claimant is aware exist. And therefore, if my learned friend is saying, well, let's say, for instance, those documents that are actually titled, let's say, MPA month business reports or monthly, quarterly performance reports are part of the category of documents that he says are set out at paragraph 77 of Swangard 1, then of course that would be perfectly appropriate. But at this stage, we have no idea as to what these category of documents include. So that's the first point, my lord. The second point is, Your Lordship, and I referenced a document, a table, if you like, and my apologies is not in the bundle, but it was the table that actually referred to EBITDA growth. And I have the table in front of me. It's there are various columns. There are about 5 columns. It talks about operations, and within the operations column, it refers to EBITDA managerial growth, refers to various business units such as Ostrava, Glati, and Primary Steel Europe over various periods of time. So the second column is dealing with the period April 21 to March 22. The third column is dealing with the period April 20 to March 21. The third column is July 19 to March 20, and the fourth column is April 20 to March 22. And what this table, as I understand, shows is the growth in EBITDA by reference to numbers. And the claimants or the instructions are that these numbers are by reference to the various specific documents that are referred to at repeated original request 13. So MPA month business reports, performance growth reports, monthly and quarterly performance reports. And so I see the point being made at paragraph 77, but the only concern is that it's very generalized and very general, and we don't know if those category of documents actually include the very specific documents that the claimant has referred to in that request.
But you'll know within a couple of weeks, won't you?
Yes, depending on when they are disclosed. I mean,
Well,
at the moment, my learned friend, or rather the documentation shows that they are ready. There are 250 documents. So the question would be if they can be disclosed quickly within days of the order being made and within days of this hearing, that would remove the concern about any delay in timing, especially because the expert reports are due to file their report on the 24th of February.
Yeah.
Or January, I think, actually. Is that January or February? The original date was the 24th of January in your CMC order. I think that has been moved by consent to a date early in February.
Right. But I'm afraid I feel quite strongly that you should see what's given.
In which case, Your Lordship, I won't press this point any further. As I said, the issue is one of timing and the impact on the timetable. And so if Mr. Trotter can persuade, well, if Mr. Trotter can convince us that these documents, the 250 odd documents, will be disclosed as soon as practically possible within days, then I suppose that also removes the concern about timing. So the time taken to review the documents, establishing what the gaps are, and then writing back to the defendants about what the gaps are and requesting specific disclosure. And then I suppose,
yeah.
And then the only concern would be, and again, it goes back to the issue and the concern that we've had in bringing this application, and that is the impact on the timetable. How would any dispute be resolved, and what would be the timetable to resolve any dispute? Would Your Lordship be prepared to determine any issues of contention on the papers?
When applications are made, the court decides how they're to be dealt with, sometimes in consultation with the judge. And it depends on the application. I'm not going to give a carte blanche that I will be available 24/7 to deal with every application, every complaint. But there's other judges around if I'm not available.
Understood, Your Lordship. And so just to summarise, the only concern is delay and impact on the timetable. And if Mr. Trotter is submitting that the documents referred to at paragraph 77 will more or less include the documents that we request.
He can only go on what the witness says, and I don't think he's gone beyond that. So I'm not going to ask him for some personal undertaking. But what I will ask him is when on his instructions it is likely that these 250 documents will be made available, subject to discussing the confidentiality point, which I know is linked with this.
Yes, my lord, I'm just taking instructions on that at the moment. I know that they can be produced reasonably quickly. And the truth is, if the confidentiality issue had been resolved, then no doubt they would have already been produced. But I'll take instructions on that. I'm waiting for a final response.
Do you want to deal then with the confidentiality point while we're waiting for a response on that?
Yes.
What is the issue that you want me to resolve?
So the issue, my lord, is simply putting in place an adequate confidentiality regime, and we've proposed one. We've had some limited comments back.
I've forgotten where it was.
I'm not going to dredge up all of the procedural history, but I do need to deal with the suggestion that this has just been raised at the very last minute by us.
Why do you need to deal with that?
Well, if it doesn't concern your lordship, then I want to.
Throughout this hearing, I've been trying to focus on the things to be decided rather than the history of what hasn't been agreed or done or whatever.
Thank you, my lord. Well, I won't then trawl through the correspondence.
No.
perhaps I do need though to look at the agreement that has already been reached in correspondence.
Where's that?
There's the first, I think you've already seen these letters, but the first one is at our letter on page 460.
Page what, 460?
Yes.
Yeah.
So paragraph 4 at the bottom of that page, we invite your client to agree and undertake. First, that the confidential information will only be used for the purposes of these proceedings and only disclosed. But I mean, it says for the purposes of these proceedings is the restriction on collateral use anyway. So it's the next bit that matters. Only disclosed to the following receiving individuals. So the documents are only to go to the legal representatives, the expert, and anyone else agreed in writing.
Why not a judge?
Well, quite. And and my lord will see that in fact the order that we've formulated now is more generous than this, and your mother will be pleased to know it does include the court. It also includes some other necessary people.
Right.
I'll come to that order in a moment, but just dealing with what was set out in correspondence. Then B, to the extent your client wishes to use the confidential information in a pleading, witness statement or submission and so on, you'll give us 14 days notice of the intention to do so. And then the parties can agree appropriate redactions, or if we can't agree confidentiality measures, then an application can be made.
So to interrupt cross-examination, if a witness gives an answer which is contrary to some documents which are confidential, you can't cross-examine him on that document for 14 days.
No, my lord, no, that's absolutely not the intention, because this issue.
That's how I read it.
Well, again, this is why we have wished to formulate it in a proper order rather than in a couple of paragraphs in a letter, because of these sorts of issues that arise. But the intention is that it's 14 days before the trial bundle, effectively, so that any issues can then be fleshed out. Now, that was then agreed. If we look at 464.
Yeah.
It was agreed in slightly equivocal terms. It's quite difficult to understand what this means, but paragraph 3, our client is content to agree the proposals set out in those paragraphs we've just seen, provided that we reciprocate, and specifically in relation to the sensitive information relating to the ArcelorMittal group.
Yeah.
So my lord, remember that there's an issue about the value of the ArcelorMittal shares that he's said to have given up and the reasons why he left ArcelorMittal's employment.
Yeah.
And then this at paragraph 4, our client's agreement to abide by the proposal does not amount to a formal undertaking by our client and this firm. So I'm not quite sure, but I think what's being said there is it's an agreement, but not an undertaking to the court. That's the most sense I can make of that.
Okay.
Now, after that, I should say, I don't think we need to go back to the request to produce, but both parties in their objections said we offer these counter proposals or we agree to produce documents subject to an appropriate confidentiality regime. So it's always been the contemplation that a regime would be put in place. Now, we proposed an order to give effect to this regime that we thought was agreed and that both parties insisted upon. And we did, in Mr. Singh's reply witness statement, have some engagement with that order. So can I show you Mr. Singh's comments, the matters he was concerned about?
What page? What paragraph of his?
It's at paragraph 50, internal page 14.
Okay.
Or in the bundle, it's page.
I've got it.
Thank you, my lord. So at 50, it said the provisions of the confidentiality ring order are very onerous.
What paragraph?
50.
14, power 50, but I'm not sure what the bundle page is. Okay.
The bundle page for Ms. Arnold is 117.
Okay.
So it said they're onerous, and the 3 points taken, pursuant to paragraph 9, the claimant would not only need to request a copy of the confidential document, it needs to do it so in a reasonable manner and give an explanation. Paragraph 11, it would be required to start potentially long and costly process. And paragraph 26, a point about costs.
Yeah.
Now we've written and dealt with those concerns. Not sure if your lordship will have a bundle that extends to page 598.
I don't think so. I'll try if you like. But 598. No, it only goes to 551.
Never mind. We can do it by reference to the order. So 526.
So
I should say, in broad terms, what we've done is written to my learned friend's firm with addressing those three concerns and proposing amendments to those three paragraphs, which effectively take out the parts that my learned friend was worried about. And we've also produced a revised draft of the order reflecting that. Now, my lord won't have that in the bundle. What I'm going to do is to go to the original order, just explain how it works and explain how those concerns that my learned friend has raised deal with the point.
Right.
So the order is at the original order is at page 526 of the bundle.
Yeah, I've got that.
So just going through it. First of all, there's a series of definitions. Confidential information, and this appears throughout, it's the information which has been designated by the disclosing party. So how these orders work, as I'm sure my lord knows, is that when you disclose documents to the other side, you designate them as going into the confidentiality ring.
Yeah.
And then it also extends to other documents which refer to the confidential information to make sure that, you know, if one writes a letter that sets out the revenue figures for a particular year, that it's swept up by the confidentiality protection. One doesn't circumvent it somehow in that way. 1.2 confidentiality ring members are the people listed in the schedule to the order as amended from time to time. And that's effectively the legal representatives and so on. 1.2.2, and this is where I say it's more expansive than what was set out in correspondence. It extends to other incidental personnel who are going to be necessary, obviously, to process documents. So we've got secretaries and business services, support personnel, e-disclosure, and so on. So that the purpose of that is one doesn't need to make an application to get every single person who handles these documents into the ring.
Yeah.
Similarly, 1.2.3, external e-disclosure, and 1.2.4, the court and its personnel. Yeah. That's the point that my lord made earlier.
Yeah.
Disclosing parties straightforward. The person who disclosed the document has the meaning in the rules. And then excluded information is things that are not confidential, even if they otherwise would be. And this is all quite intuitive, things that are generally public.
I see, yeah.
1.5.
Yeah.
Things that the parties agree are not confidential. Information that's subject to an order, not treated as confidential. Information that's available to the party because it appears in the document that's been disclosed, which has not been designated as confidential. So it's the idea is to make sure that it's confined to the material that's designated as confidential and not things that are otherwise public. And then we come to the operative parts. So B, designation of confidential information. This is really just the mechanism by which when we disclose, when either party discloses information, you simply designate it as confidential information, but also explain why the status is being claimed. So there's not just some sweeping claim to confidentiality. And then in 3, there's a list of things that, the criteria by which things can be designated as confidential.
Can you just
in particular,
can you remind me whether the ring included experts?
It doesn't in terms, but it includes people listed in Schedule 2 to the order, and the intention would be that both sides would list their legal representatives and their experts, and they would be in the confidentiality ring.
Yeah. Okay, sorry I interrupted you. Yeah.
No, not at all. And so 3, we have the criteria, and these reflect what was in correspondence, but we've also put in 3.5 information relating to the claimant's employment with ArcelorMittal, because that's what the claimant said he would like to put into the confidentiality ring.
Yeah.
And then we have 4 is a mechanism to update the designation if something's been incorrectly designated one way or the other. And all that it requires is that notice is given, and the receiving party can challenge it if they want to.
Yeah.
5 is a mechanism for challenging a designation. So if a party wishes to challenge the designation, they can at any time write to the disclosing party. If a challenge is made, then there can be consent, it can be agreed. Response has to be given within 7 days so that neither party can just sit on their hands and hold up the process.
Yeah.
And if the status, if no response is received within those 7 days, then you can apply to the court for notice. To vary it. And the deadlines 5.4 can be agreed. So all this is quite vanilla. And then part D, we come to how the confidential information is to be used. And in broad terms, 6, it's only to be made available to the confidentiality ring members. Those are the people we saw listed earlier.
Yeah.
7 provides for how it is to be labelled, because otherwise there's quite a lot of these documents and it's no longer clear what is and is not confidential once they've been shuffled around a bit.
Yeah.
8, just to make clear, nothing prevents making notes or copies, preparing reports, and so on. 9, for each document designated as confidential information, the disclosing party shall provide upon a request from the receiving party a copy with redactions and or a copy with the square brackets, which indicates the particular confidential information within the document. So that's a mechanism to make sure that the receiving party can ask the disclosing party to be more specific about exactly what it is in the document that's confidential. Now, I said I'd refer to the objections my learned friend had. This is one of those paragraphs. So my learned friend's client said in correspondence, well, we don't like the fact that the request is subject to a sort of reasonableness threshold. We said, well, that's fair enough. So we've struck out reasonable on the second line there.
So it reads upon a request.
Upon a request. So that's fair enough. Therefore, we don't get embroiled in some sort of dispute about whether the request is reasonable or not. And then my learned friend also said, well, we don't like the idea that we've got to provide an explanation for each request. And we're content with that as well. So we've deleted the words starting on the third line, explanation of why it is needed by the receiving party and so one ends up with, which shall include a suggested reasonable time period.
Yeah.
So that's that paragraph. 10, anyone can release the party from the required beneficiary can release the other party from the requirements. 11, this is the second important mechanism in this order, that where a confidential information is proposed to be included in by a party in a pleading, witness statement, written or oral submission, or hearing bundle, and that really deals with the point my lord was making earlier, then at that stage there needs to be 14 days notice. And so really the intent of this is just to make sure that either party is in a position to make an application for part of a hearing to be heard in closed, or for particular redactions to be applied, or for whatever confidentiality protections are necessary, and that 14 days notice is given. Now, this was the second paragraph on which my learned friend commented. And it said, well, we don't like how elaborate this mechanism is. So we've said, okay, that's fine. We'll just delete 11.2 and 11.3. And it becomes a pure notice provision, and then the parties can do what they will. I mean, the scaffolding there was meant to ensure be a guide to the parties to engage constructively and come up with redactions. But in a sense, it doesn't need to be in the order because the parties can cooperate, as I'm sure they will.
Yeah.
Then 12, production of further copies should be those required by the confidentiality members so that we don't have proliferation of unnecessary. 13 provides for the destruction of the confidential information that we don't have, 100 people with confidential information just lingering on their computers once this is all over. But there's carve-outs there to make clear it doesn't apply to the lawyer's notes, working documents, skeleton arguments, and so on that have been produced.
Judge's laptop.
Sorry, I'm sorry.
Judge's laptop.
Yes, well, perhaps the judge could be excluded entirely from this. But in fact, it doesn't bite on the court because the party is to notify their confidentiality ring members. I mean, we could certainly make that provision for the avoidance of doubt, but I don't think anyone will come after the court for a breach of the order.
Yeah, okay. I think it would actually be useful to make it clear that the court will obviously not want to flout the confidentiality of the documents, but I don't know how things are stored on the court file after cases are finished. And
yes.
Certainly in terms of my own gadgetry, I'm not very good at making sure that all records, all traces of a thing are deleted.
That's perfectly fair, and I don't think anyone will object if we just exempt the court entirely from this requirement. Then there's a point about unauthorized disclosure. The solicitors, and this just applies to parties, so the court is not caught by this anyway, but solicitors representing the party who's unauthorized disclose things without authorization give notice, use reasonable endeavors to prevent further distribution, and then use reasonable endeavors to secure agreement in writing not to further disseminate any confidential information. So that's just a fallback in case something goes wrong.
Yeah.
Then in F, we have mechanisms for adding or removing confidentiality ring members. And it basically involves seeking permission from the other parties. There's then quite short time limits to make sure that people don't sit on their hands about these things. Usually it's very uncontroversial. A new lawyer joins the team. They're added to the confidentiality ring quite quickly.
Yeah.
That mechanism runs through to 22. And there's Schedule 2 to the order, which is just a list basically to be kept updated. Now, all these mechanisms, I should say, all appear in confidentiality ring orders that are made all the time in the Commercial Court in London.
Yeah.
And particularly in the Competition Appeal Tribunal. Now, disclosure pursuant to a court order, again, the carve out at 23, so that if people are ordered by a court somewhere else in the world to disclose information, then they can do so, and they don't get stuck in a difficult position where they have to breach one order or the other.
Yeah.
And then we're really into the machinery now. H, permission to enforce costs. This was the final objection that my learned friend had, was the costs of compliance. They didn't like that this was costs in the case. We said it's going to be a bit of a pain at the end of the case to try and weed out the costs that related to compliance with the confidentiality order, but so be it. We're happy to make it each party bears their own costs of compliance with and drafting the order. 27 liberty to apply, and 28 to 31 how notices are to be given. And then in Schedule 1, over the page on 539, we have the undertakings, which are to be signed by the confidentiality ring members. Because, of course, the order can only take effect against the parties. One needs some way of making it bite on the individual confidentiality ring members.
Yeah.
And the definition of confidentiality ring member requires that a person sign an undertaking before they're admitted to the ring.
Yeah.
And again, these undertakings are signed by a great many lawyers in London all the time. There's nothing particularly controversial in them. I've signed many of them myself.
Mm-hmm.
And all they do is make sure that the information is not disseminated further. So, my lord, it sets out the machinery that's necessary to make this whole thing work. A few paragraphs in correspondence just isn't really a sound basis on which to proceed, because it leaves very unclear who the people are who are going to have access to the information, how they're going to be added and taken out, and so on and so forth. And so that's what we've done. We've had comments from my learned friend. We've addressed those comments. Unfortunately, we haven't had any further engagement. We don't know whether there's any other specific points that are a problem. What we have had is in my learned friend's skeleton argument. We're back. I think we're now in the body of the skeleton argument rather than the annex, possibly for the first time in this hearing, at paragraph 80.
80. 80.
Oh, sorry. First, can I do 90?
Yeah.
So I think this is in relation to a different issue, but that we there have in the middle of paragraph 90, the claimant is prepared to agree a confidentiality measures, including redactions, restricted access, or a confidentiality ring.
Yeah.
So that's the principle. That's encouraging.
But
then we go back to, I'm so sorry.
And saying, but not to the extent the defendant is seeking.
Yes. And so one wonders quite what the particular concern is, but we see that at least the concerns in a general sense, if we go back to 80.
Yeah.
There's a bit of argy-bargy about the background, but then towards the end of the paragraph, we say the claimant sought to ensure that the confidentiality protocol adopted is fair, reciprocal, and does not unduly hinder the claimant's ability to access and use relevant documents.
Yeah.
So those are the three things that my learned friend's concerned with. I don't think there's anything in the confidentiality ring order that I've been through that is unfair. But of course, if there are particular comments, then my learned friend can make them. Certainly the order is reciprocal because both parties can disclose the material they've said they were going to disclose into the ring. And it doesn't in any way hinder the claimant's ability to access and use relevant documents. That's not the function of the order at all. So for our part, we don't really understand the objection to this. It's been common ground for a very long time that's been required. All we're trying to do is to put the machinery in place. So if there are particular concerns, then I'm sure my learned friend will ventilate them now that we've been through the order.
Ms. Arvid?
Yes, Your Lordship. Before I address my learned friend, I just want to make one comment. I don't think it's helpful for my learned friend, Mr. Trotter, to make barbed criticisms in the course of his submissions. I mean, it's been continuing all afternoon and it's quite tiring. Dealing then with the submissions that have been made. Your Lordship, just to provide some context to this, the agreement that was reached was that there should be ordinary and usual confidentiality provisions attached to commercially sensitive and financial documents. And to that extent, Your Lordship, the rules actually, in fact, deal with this in terms of the use of produced documents. And before I take you to the rules, it's important, Your Lordship, to give some context in terms of why it is that we say the defendants want an order of this nature. And to that extent, if I could invite Your Lordship to turn up page 90, and it's paragraph 79 of Mr. Swangard's witness statement. And what in fact, paragraph 79.
79, okay, I've got it, yeah.
And what in fact my learned friend is saying, or rather the defendants are saying in the context of Mr. Swangar's witness statement, is that there might be some general sensitivity here, but actually it's heightened by a number of factors. And those are that there are several proceedings ongoing around the world that involve entities in the Liberty Group. These include winding up proceedings related to Liberty Commodities Limited in the High Court of England and Wales, brought by White Oak Commercial Finance. A claim brought by Greensill Bank AG, acting by its insolvency administrator, against Zurich Insurance Company Limited in the High Court of England and Wales, in which Mr. Gupta, Liberty Commodities Limited, Liberty DMCC and Liberty Commodities Group, PTE Limited, are named third parties. Regulatory investigations in the UK, France, Italy and the Czech Republic. A criminal prosecution of Mr. Gupta and other directors over alleged failure to file accounts in the UK for 76 companies, including entities in the Liberty Group. A range of proceedings brought in Australia in respect of Greensill Bank, Credit Suisse, Insurance Australia Limited and others. While no GFG entity is a party to these proceedings, the concurrent wrongdoer defence has been pleaded in respect to a number of GFG companies, including Liberty DIFC, for example, by Tokyo Marine and Nikaido Fire Insurance, in proceedings between White Oak and Insurance Australia Limited in the Federal Court of Australia. Multi-jurisdictional arbitral proceedings between companies in the GFG Group and ArcelorMittal. This litigation is subject to stringent confidentiality protocols. However, I note that the substantive arbitration proceedings, as well as a number of satellite disputes in at least 2 other jurisdictions, are ongoing. Further, GFG remains in settlement discussions with Greensill creditors and administrators, including Grant Thornton. The sensitivity of the group's financial information in particular remains a live issue before various courts. For example, the Liberty Commodities Limited winding up proceedings featured a satellite dispute regarding the leaking of information to the press by an interested party. In the director's disqualification proceedings against Lex Greensill in the UK, there is an ongoing dispute regarding the disclosure of the pleadings to the press, which I understand may contain information relating to GFG. The release of financial material of the Liberty Group would be highly prejudicial. In particular, the period relevant to these proceedings overlaps significantly with GFG's peak usage of Greensill facility, central to the litigation above. Further, the dissemination of GFG's financial data may well impact the dynamics of ongoing settlement discussions with Greensill creditors in a negative way. The settlement discussions are a critical stage, and further variables in the form of information which might be leaked to them could continue an extended negotiating period and could possibly cause them to collapse, putting at risk many thousands of jobs in the UK, Australia, and United States. And so the first point is, my lordship, that the reason why these confidentiality provisions are being sought is not just because these are confidential and financial information, sensitive information, but rather there is something beyond that. And your lordship, what in fact the claimants are seeking, and the real context to all of this is therefore provisions that are highly onerous, we say, and go far beyond what is usually required. And my learned friend keeps saying, well, these are the usual orders in the UK. Well, your lordship, we're not in the UK, we're in the DIFC, and the DIFC makes provision for collateral use or prevents collateral use of documents by way of its rules. And so, your lordship, to that extent, if I could invite you to turn at 28.64, the rules are quite clear. There is an obligation on the parties to whom a document has been produced that the party may...
Hang on a second. 0.64. Yeah. So
subsequent use of produced documents. A party to whom a document has been produced may use the document only for the purpose of the proceedings in which it has been produced, except where the document has read to or by the court or referred to at a hearing which has been held in public. The court gives permission, or the party who produced the document and the person to whom the document belongs agrees. And so, your lordship, there is an obligation in any event on the parties to only use these documents for the purposes of these proceedings. Secondly, 28.65 permits the court to make an order restricting or prohibiting the use of a document which has been produced even where the document has been read to or by the court or referred to at a hearing which has been held in public. And 28.66, an application for such an order may be made by a party or by any person to whom the document belongs. And so, Your Lordship, it's rather premature for my learned friend to seek these sorts of confidentiality provisions at this stage, when we don't know what the documents are, we don't know what the nature or the precise nature of the confidentiality is.
This is chicken and egg, isn't it? You're not going to get the documents until there's some confidentiality agreement.
Well, we're prepared to agree
to
some...
You say you can't tell whether you need a confidentiality agreement until you see the documents. So it's an impasse.
Well, Your Lordship, we have agreed, and we're under an obligation not to use these proceedings by the rules for any collateral purpose. At this stage, that should be sufficient. I mean, the sense given by Mr. Swangard about the use of these documents, I mean, the risks are, we say, exaggerated. I mean, the risks of leaks and the potential consequences. They haven't, nothing that Mr. Trotter has said gives rise to an argument of these proposed additional restrictions that give rise to the confidentiality ring order. And in any event, the rules themselves mitigate for these risks that I've taken you to. There is no, the parties are not permitted to use any of these documents for a collateral purpose, and nor would they. And Your Lordship, in that sense, the courts have consistently held that the importance of relevance evidence in resolving disputes is important. And there's a line of authority to suggest that confidentiality orders should not be overly restrictive, and there shouldn't be any sort of pre-approval of every document use that is intended and every sort of document that might even refer to any sort of confidentiality provision. We say it is onerous. It places an excessive burden on the claimant about the use of these documents. And therefore, Your Lordship, we say that paragraph, or rather rule 28.64 is sufficient for the defendants to disclose these documents that they say are confidential to us. The rules provide for a prohibition on using these documents for any collateral purpose. And Your Lordship, we can give confidential undertakings for a short provision until such time as we've reviewed the documents, if that's an alternative. It may be an alternative way to proceed. But we give confidentiality agreements that we comply with our obligations under the rules, and then review the documents and assess whether or not, in fact, these documents do, there is a confidentiality provision applicable to these documents, and whether or not they should form part of the very extensive confidentiality order that's been proposed by my learned friend. That's what we say about the principle of the matter, Your Lordship.
Is there anything, I take your point, but is there anything in the draft order that I've been shown which materially goes beyond 28.64 to the extent of offending public policy in some way?
Well, Your Lordship,
I mean, a lot of it's just mechanics, confidentiality rings and so on, which I know from arbitration, and I'm sure it's right from the court's point of view, restrict the number of individuals who have access to documents and so on, and allow people to join and leave the group and all sorts of things. Those are all mechanics and quite sensible.
Yes, Your Lordship. And I mean, this is the point. I appreciate what you're saying about the mechanics, but this isn't an arbitration. And I hear what you say about the public policy point. Mechanics, if we look at page 527, I mean, in terms of, and that's the definition of confidential information.
527 of what?
Of the bundle.
527, okay.
Page 527, that's the definitions.
Yeah.
I mean, my reading of it is that why in my submission it's problematic potentially is that it allows the disclosing party, which is the defendants, to unilaterally decide and label which documents they consider confidential. And for instance, documents
subject to challenge later on, as I understand it. I think Mr. Trotter showed me something that allowed parties to say that it shouldn't be regarded as confidential. Perhaps I'm wrong.
Paragraph 5, my lord.
Paragraph 5. Yeah, challenges to designation. Yeah. Doesn't that give you protection?
Yes.
Any concern? You might say it's cumbersome, but these things.
Well, all of this is
more and more elaborate.
And that's the general submission, that this is quite cumbersome and it's quite onerous, really, and it just puts an additional burden on the parties when we already have a very tight and contracted timetable. In terms of
in reality, although it looks, it's 10 pages worth of procedure and so on, in reality, someone will send an email saying so and so has left the team and so and so has joined it. Please, can you note for purposes of the confidentiality ring the change of personnel? And it becomes routine, I think. I may be wrong. Tell me if I'm wrong.
Well, Your Lordship, I think as I go back to my general point, it is cumbersome, it is over the top, onerous, and it places an additional burden on the parties, in particular the claimant, in circumstances where we don't necessarily consider, or rather reading Mr. Swangard's witness statement, it might not, the confidentiality concerns probably aren't borne out really by the usual standard label of what is confidential and sensitive. Your Lordship, can I just also then address the other aspects of this agreement?
Yeah.
And the mechanics?
Mr. Trotter's identified 3 areas where your side have raised issues, and I think all 3 have been dealt with. Whether you're satisfied with the way they've been dealt with, I don't know.
Well, Your Lordship, just dealing with this agreement on the face of it, I mean, the other sort of problematic part of this agreement is at paragraph 9, and I couldn't understand Mr. Trotter's submission about whether or not this has been dealt with, but the problem with that is that as it currently stands at page 532.
Yeah. He was going to delete the word reasonable and delete the words an explanation of why it is needed by the receiving party and. So in other words, you if you want to get an explanation, so this is for someone wanting to challenge confidentiality, I think. And you don't have to give an explanation.
I beg your pardon, as I understand it, paragraph 9 as proposed is that we would disclose the documents, or rather they will disclose the documents to us.
Yeah.
Then we had to request production. They would disclose in a reasonable time.
Yeah.
Which, if my reading is correct, is a rather long-winded process.
Why?
And well, shouldn't they just disclose this document to us? And if they consider it's confidential, they mark it as confidential rather than.
Yeah, and if you want to challenge that, you request what is info as to what has been redacted. I think.
My Lord, I hesitate to interrupt. This is intended to be helpful. It's certainly not the case in the order that there's any further step. The mechanism of the order that we went through before is the disclosing party discloses the document and at the time of disclosure designates it as going into the ring.
Yeah.
And so all the confidentiality mechanisms apply. Then the paragraph we're looking at the moment just relates to a circumstance where the receiving party wants to have a copy that identifies the specific information within the document that is confidential. And so it makes provision for the disclosing party to provide a redacted copy or a copy with square brackets around the confidential information.
Yeah.
And that can be done purely on request. There's no burden at all on my learned friend. And then when it comes to overcoming the confidentiality, there's two routes. One is the one that my lord identified, making a challenge. But in a sense, it's hard to imagine that.
Can't remember where that is.
That's in paragraph 5 that we saw before.
Yeah.
In a sense, it's hard to understand why that would ever be necessary, because unless my learned friend wants to disseminate the information, which obviously she doesn't, then all the necessary people will be in the ring. And the second mechanism, which is really the relevant one, is paragraph 11, and that all that's required to use the documents in a public hearing is just to give notice. So I'm sorry about that intervention. I really don't mean to interrupt my learned friend's flow, but there's a bit of confusion about how the order is working. So I hope that's helpful.
That is helpful. But going back to paragraph 9, if the document disclosed already has markings on it as to the part of that document that's confidential, then it really removes the process of us then requesting which part of the document is confidential, and then the disclosing party coming back to us, or the defendants coming back to us and telling us which part. So if the starting, isn't it preferred or preferable for the starting point to be that the defendants, if they consider a document to be confidential, they mark within that document what part of that is confidential, rather than there being sort of a two-stage process? Because at the moment, as I read it, it is a two-stage process. That's my kind of issue with paragraph 9, the mechanism provided for in paragraph 9 as it's currently drafted.
Well, let's have
Perhaps I can clarify. Well, it would be useful for me to clarify that.
Yes,
so
you would.
the documents are disclosed and designated as confidential. So my learned friend has the documents and she can use them in the proceedings. Just distribute them to the people at her firm and the expert who are inside the confidentiality ring, and we can all get on with the work of this litigation. Now,
sorry,
of course,
and the documents at that stage have no redactions.
That's right.
Yeah.
Unless they've been redacted for the separate purpose that my lord referred to earlier, particularly sensitive material that is not really relevant or material. Yeah. That doesn't need to be even disclosed to the claimant. That's a separate question. Now, of course, it's possible in theory to design a mechanism whereby we first go through all of the sensitive documents and highlight the parts of it that are confidential. But that, of course, is just an additional and probably in the end unnecessary stage, and will just slow things down. And so the way these orders work is that if for some reason it becomes necessary to identify specifically what information within the document is confidential, then a request can be made and it will be done. But that won't hold up in any way the documents being disclosed to my learned friend, because otherwise it's just an extra step in the process.
Why would it become necessary?
Well, it's difficult to imagine that it would. But if for instance, my learned friend wanted further information in order to make a challenge to the designation, they might ask, well, why do you say this document is confidential? And we'll say, well, it's because of these 2 paragraphs. Yeah. And they'll say, well, we don't accept that.
And that's covered by 9.
Yes, that's right. But in a sense, it's not even necessary for my learned friend to do that, because my learned friend could just give notice under 11 whenever they want to refer to a document, and then it will be on us to make an application. Or the other way around, if my learned friend discloses us the middle documents, then we can give notice before deploying them in a public hearing, so that the private details of his remuneration at ArcelorMittal don't get published on YouTube. Yeah. But all it's designed to do is to give people the time to make the application for confidentiality regime, for protections.
Yeah.
And that leads me on to paragraph 11. Again, if the document has been marked confidential, then what's the purpose of the claimant giving notice of use of that document within a witness statement or a pleading? I mean, isn't it obvious that that's a confidential document and confidentiality applies?
I think the idea, is to allow the other party to give notice that he's going to use it, and leave it to the disclosing party to go to court and stop it.
Precisely right, my lord. And in that way, this order, the reason the order works in that way is so that there's no prejudice to the principle of open justice at this stage. Because what we're not doing is locking up all of the confidential information for all time and saying that any document that's designated as confidential will never be referred to in a court hearing. That question is determined at this juncture in paragraph 11. And so again, it's just in order to preserve the status quo, to make sure that there's sufficient time to make an application for a particular part of the hearing to be heard enclosed, or for particular redactions to be applied, or for a restriction requiring no access to the court file to certain things, and so on and so forth. One doesn't quite know what that application will be until we know precisely what document it is that's going to be used.
But again, just sort of just following that, just in terms of practical terms, let's say we refer to a confidential document, or the expert refers to a confidential document in his expert report. We serve that expert report and it's marked quite clearly that he's referring to a confidential document. I mean, you would know at that point, you would have notice at that point on service of the expert report. So, I mean, is the suggestion that even before we serve the expert report, we give 14 days notice that this document is going to be used in the expert report? And that in itself is quite onerous, because given the sort of timetable and where we're at, it's highly likely that these things are going to be sort of kind of served up to the sort of hour. And so that aspect of paragraph 11 is concerning, because the notice is given on service of, let's say, the witness statement or the expert report. Why is it necessary to have the extra step of 14 days notice?
Well, the answer is that in that scenario, the expert report itself just becomes confidential information, because the definition of confidential information encompasses at 1.1 the information which has been designated as such, and then other documents in the proceedings that refer to it. And so the point at which notice becomes necessary is when things are being included in the trial bundle. And usually this is all agreed. One ends up with a confidential bundle and a non-confidential bundle. And there's an understanding that when you're referring to things in the confidential bundle, you do so by not reading out the contents, but by inviting the court to read them. Or if necessary, if it's necessary to really get into the weeds on something, there might be an application to have part of the hearing heard enclosed. There's nothing particularly complicated about all of this. It's just about ensuring that the material that is confidential remains designated and labelled as such, so that by the time we get to the hearing, we know what is and is not confidentiality ring information.
Lynn Friend keeps saying it's not complicated, but read in the context of Mr. Swangard's witness statement, it seems to be a backdoor attempt at trying to put these proceedings in camera. I mean, how, maybe it's just I'm being quite obtuse, but computing how this would work practically if there's a whole range of documents, which is why it is a bit of a chicken and egg situation, that it's very difficult to agree to these provisions without understanding the nature of the documents and whether or not they do attract confidentiality provisions, especially in the context of what Mr. Swangard says as to why the defendants are seeking confidentiality provisions.
As I understand the draft order, the labelling of something as confidential does not prevent it being used without any further action by the disclosing party. Because you just simply need to give notice that you intend to use it. And the disclosing party is then left to whatever remedy he thinks he has under the terms of the order. Have I got it right, Mr. Trotter?
That's right. And it's ordinarily not even necessary to give notice, because usually the parties can agree that particular information is sensitive or confidential and ought to go in a confidential bundle. If there's a disagreement about that, then all my learned friend needs to do is give notice. If her client thinks that it's important that all of this financial information be ventilated in public on a YouTube hearing,
my only doubt was about 11.1, having a 14-day notice in writing. Because if you're going to, for example, to put in an expert report, the expert report will be exchanged long before it ever goes public. Why isn't the service of the expert report with the document referred to sufficient notice in itself?
I think, my lord, the compute. Yes.
Rather than have 14 days notice of including it within the expert report.
And the witness statements, that would
Yeah.
also apply to the witness statements.
Yeah, I was just using expert report as one example.
I think that's right, and I think this can be dealt with easily by just removing from 11 the words pleading and witness statement, because as I was saying a moment ago, the effect of referring to confidential information in a pleading or witness statement simply means that the pleading or witness statement becomes confidentiality ring information itself, and so we just take that out, and so the only notice requirement arises in the run up to a hearing. Effectively, it's not necessary when we're just serving witness statements on each other, expert reports on each other, because we're all inside the confidentiality ring.
Yeah.
And just taking that to its conclusion, if it's in the run up to the hearing, then clearly one would assume that it's a cross-examination, because the first part of the hearing is cross-examination. Then it would assume that the cross-examination related to those confidentiality documents may need to be in camera. And so just to deal with this practically, to give notice of those documents to be used in cross-examination, let's say 3 days before the hearing, and if there is any application to be made about whether or not use of those documents gives rise to a hearing in camera in relation to those documents, if there is any dispute, then that's where that application is made on the morning of the hearing.
Well, the scheme of the order at the moment, of course, any such documents, they'll all be in the hearing bundle. So the 14 days before the hearing bundle is finalised, so that one ends up effectively.
Sorry, you've broken up.
I'm sorry, am I coming through clearly?
You
You broke up briefly. Can you repeat the
last?
Is
that better now?
Yeah.
Yes.
The scheme of the order at the moment is that the notice provisions triggered for inclusion in the hearing bundle, and so all of these documents will, of course, be in the bundle for the relevant hearing. It may be that there is a confidential bundle and a non-confidential bundle. If my learned friend says, well, these documents should be in the non-confidential bundle, or indeed there shouldn't be a confidential bundle at all, and here's a list of all of the documents we want to refer to in the public hearing, then the dispute can be flushed out at that stage, well in advance of the hearing. So we don't have any disruptions to cross-examination in the middle of trial, because the bundle will be compiled in advance, and if there's a dispute about what should and should not be public, then it can all be done in advance. That's what the notice provision is intended to ensure, that there's no such disruption.
Yeah. Is that okay, Ms. Ahmed?
Your Lordship, it sounds okay.
Well,
How it works practically.
You've had a fair bit of time to look at this, and I haven't, and it seems okay to me.
Yes. Your Lordship, the other kind of problem I see with this order is it's paragraph 23.2.3.
23.2.3.
And as our reading of it is that it requires us to resist an order for disclosure of confidential information if a request is made by a government agency or another court. So to resist it until we've given the defendants an opportunity to seek relief. And this is onerous on the claimant, we say. And so that should be deleted if, in fact, that's what was intended.
So, my lord, the purpose of this provision, as I said, is to make sure that no one's caught in a position where they're at risk of either breaching a foreign order or breaching this undertaking. But at the same time, it tries to do so in a way that the disclosing party at least has the opportunity to take such steps as they can in whatever jurisdiction the order may be made to protect their position and to be heard before the cat is out of the bag. So in 23.2, the requirements I don't think are particularly onerous. If an order is sought against a party, then one just needs to draw this order to the attention of whoever's seeking it, to the court. Take reasonable measures to have the confidential information treated in accordance with the terms of the order, and resist the order without the disclosing party being given a chance to be heard. Now, I'm open to different ways in which that might be drafted, but in broad terms, it's just meant to say, well, hold on, O foreign court, there's someone else who might be affected by this, so we ought to just give them a chance to be heard before we make any orders. And then 3...
Sorry, Karen. Yeah.
So sorry. And then 3...
24 provides a sort of fallback that if the local law or whatever it is requires you to do something without having time to serve all these notices, you have to provide it.
Exactly. If in the end the foreign court says, you know what, we don't care about the confidentiality ring and the DIOC, we want you to hand it over now, then that is what it is. And we're not going to put anyone in breach of a foreign court order.
Yeah.
And the same is true of the parentheses in 23.2.3. So not unless required by the competent court of jurisdiction to do so, despite having complied. So if the foreign court says, well, you've shown us the order, you've asked us to give the disclosing party a chance to be heard, but we don't agree, then the receiving party is relieved from the obligation in 23.2.3. So if there's some specific amendment that my learned friend would like to this to make it less onerous somehow, then I very much welcome any suggestions. But it seems to me it's certainly not intended to be particularly onerous.
Well, Your Lordship, there is some inconsistency between 23.2.2 and 24, and it may be that if we're allowed an opportunity to give maybe reformulated wording, that would be greatly appreciated.
What is the difficulty?
Well, we say there is some inconsistency between 23.2.2. So the onus is on the claimant to resist an order, and we appreciate what you say in 24, but what does that resistance entail? Does it mean that the court that Mr. Kahlon has to go and instruct solicitors, has to engage solicitors to write on his behalf and to protect the position of the defendants? I mean, what is that resistance that the defendants consider would be reasonable under the circumstances? And then 24, whilst my learned friend says that they don't want to put anybody in a position whereby they're in breach of a court order, but then how does that sit with resisting the order? And so we would be grateful for a bit of time. I mean, my lordship, perhaps we can provide a red line version of this in light of the discussions that we've been having this afternoon.
I'm concerned that if we go away from here without agreement, it'll be another few days, longer before you get your documents, longer before you can see whether they're adequate, and so on.
Well, Your Lordship, in light of the discussion that we've had, we can, within or relatively soon after this hearing, within 24 hours, provide a red line version to the defendants.
So I'm not available for a hearing if you can't agree it for about a week.
Well, can I cut through? I might be able to cut through this quite easily. Yes. There's a concern about what's meant to resist. I think that 23.2.2 could simply say request the court not to make an order without the disclosing party being given a reasonable opportunity to be heard. And that might alleviate my learned friend's concerns about needing to instruct solicitors and expend costs and so on. I mean, I think all that really needs to be done is tell the court that the order exists and ask them not to make an order until we've been heard. That's really should be enough.
But Your Lordship, why should it be on Mr. Kahlon to make any requests on behalf of the defendant? It's just,
Well,
I mean, isn't it enough for us to give notice to the defendants that we've been asked by a regulatory authority to provide the information? We notify the defendants, and that's as far as it goes. I mean, then whatever submissions the defendants want to make about the documents, they can make them to the relevant court or the relevant agency. I mean, Mr. Kahlon, the claimant's going to be under an obligation, under a court order, obligation to provide these documents, and it's not for Mr. Kahlon then to fight the defendant's corner. I mean, we just don't understand the utility of this. Isn't it simply sufficient to say, well, if there is a request made by any court or a regulatory agency or a government agency, then notice is given to the defendants as soon as reasonably practicable, and then it's up to the defendants what they do. I mean, it's not for the claimant to jump up and down and tell the relevant agency or the court, well, don't do anything until the defendants have had an opportunity to speak to you. It's not the claimant's concern.
It would have been helpful if some of these points had been made before the hearing. But nonetheless, Mr. Trotter, what would you say to the suggestion?
Well, I mean, I agree with that observation. But again, all we're asking is, of course, we won't be party to any of these proceedings, which is why we need to rely on the claimant to at least draw the order to the attention of the relevant court. And it goes both ways, because, of course, my learned friend may disclose information into the confidentiality ring, and the Liberty Group is subject to litigation elsewhere. And so it goes equally in my learned friend's favour. But I mean, one way of dealing with this, simply to cut through it, may be simply to delete 23.2.2 and 23.2.3, if those are the paragraphs that are causing difficulty, so that the only obligation is to draw the attention of the court or agency to the order, which I don't think could be said as particularly onerous, and then to replace 22.2.32 with a provision requiring, as my learned friend suggests, to give notice to the disclosing party.
My Lordship, to simplify this, we simply say that all of that is, whatever is said in 23 is unnecessary, apart from the fact that if there is confidential information being sought, and is the subject of a court order, or is being sought by a government or regulatory agency, that the parties, and of course the claimant is also within this and subject to this, that the parties will give notice as soon as is reasonably practicable, and that's the end of that. I mean, why do we have to go any further? And of course the claimant is also subject to this. Why do we need to go in terms of whatever we have to do in resisting or sending orders or doing anything of the sort?
I thought Mr. Trotter just suggested getting rid of those. But
my understanding was there was some parts of it that he wanted to keep, and I'm just simplifying the whole of 23 to say, if at any time any confidential information is sought or made the subject of a court disclosure or discovery order or government agency or similar anywhere in the world, the party upon whom the order is served shall immediately give written notice, or not immediately, rather, give written notice as soon as is reasonably practicable to the legal representative of the party who provided the confidential information, full stop.
Yeah, that's I think what Mr. Trotter was suggesting. I think.
Well, my apologies for misunderstanding him then.
The dispute is now extremely narrow. The only part that I was proposing to retain was 23.2.1, because 23.2 concerns the situation where the order has not yet actually been made, where it's sought on notice to a party, and before the order is made, that party will have an opportunity at least to draw attention to the order. And it's a very narrow point. Really, in my Lord's hand, my Lord will have a view about whether this is onerous or not.
But let's take this in practical. if let's take this in practical terms, if we give you notice that a government agency or another court order has requested the confidential information as soon as is reasonably practicable, the defendants can then take steps to draw this order to whatever relevant agency has made the request. I mean,
there might be a slight time delay between the two things. It seems to me I'm going to resolve this, that in 23, the introductory wording stands 23.1, delete immediately and replace by as soon as reasonably practicable. And then 23.2 it goes, just runs straight into any party against whom such an order is sought or made shall rather than must draw this order to the attention of any such court or government agency.
Thank you.
So delete the rest of 23. I think it can go straight on to 24 then. Is that right?
I think my learned friend will probably. So I'm sorry, just a moment.
Do we need 23.3?
Well, it's for the avoidance of doubt provision anyway, so I suppose it's strictly ocios, but it just makes clear that this doesn't apply to a disclosing party. So if it's the disclosing part, if an order is sought against someone who's disclosed their own confidential information in these proceedings, there's no need to give notice to anyone because, of course, they can just defend themselves.
Okay, fair enough. That could be 20. Happy with that, Ms. Ahmed?
yes.
Okay, so keep 23.3. I'm not sure how the numbering will go. It'll still stay as 23.3. So we get rid effectively of 23.2.2 and 23.2.3 and the few random changes I made while dictating.
Thank you, my lord. We have those.
Someone has a note of them, presumably?
I'm sure various people do.
Yeah, okay. Happy with it otherwise? I know you're not happy, but I'm content with it otherwise. I've already made the deletions in 11.
Your Lordship, there is a couple of other points, and maybe these are drafting points. I think paragraph 13 and paragraph 15. If we look at paragraph 13.533.
13.533.
Yes. Yeah, 7 lines down. The parties, capital P, understood to mean the parties in this litigation, shall notify the other parties. Not quite clear who these other parties are, and therefore.
My learned friend's right, that should be capitalised.
Sorry?
I'm sorry. My learned friend's right if the intention is that should be capitalised, the second parties.
Right, the other parties. Does that solve it?
Yes.
Right.
And then paragraph 15, the proposing party seeking to designate an additional person as confidential ring member must seek permission in writing from the other parties. There are no other parties. I think that should read other party.
There are 2 defendants.
Understood. Your Lordship, I don't have any other points on the agreement itself.
Okay, so this will come as a separate order, I think, rather than be part of the rest of what we've been talking about. And I'll make an order in those terms if someone can draw it up or help the court draw it up in a formal way.
Of course, my lord, we will do that.
There
Is
are
there anything else we need to discuss?
Yes, Your Lordship, inspection and disclosure statement. In terms of inspection, whilst Mr. Swangard deals with the KS email and the WhatsApp, and we had some discussion about that yesterday afternoon, we still seek an inspection or access to the devices where those documents were harvested, as well as the originals. And that's the order that we seek in terms of the KS documents.
Sorry, just one second. Because of the what I would propose to do about 13, just for the avoidance of doubt, is refuse it with liberty to apply.
Your Lordship,
or dismiss it with liberty to apply. It doesn't really matter whether I say refuse or dismiss. That's 13, because you're going to look at what's given to you.
yes.
14.
Yes.
Yes.
I beg your pardon. I jumped to inspection, Your Lordship. There are those other requests, and now they have
14
been.
is not in dispute. Not in dispute, is it?
No, Your Lordship, but we have only received 4 and 45, so 49 documents in total. And so, Your Lordship, it may be that that's just dealt with in the disclosure production statement, document production statement.
Yeah,
as
and
to
then you pick up individual gaps that you spot when you go through thoroughly.
And obviously the disclosure statement itself will then, we can understand what has been done in terms of a reasonable search and the electronic data and so forth.
Yeah, I'll make an order for a disclosure statement. Well, it hardly needs to be made the subject of an order because it's covered by 28 point something.
20.
28.20, but I think maybe given the state of relations between the parties, it's worth repeating the requirement of a disclosure statement in the body of the order.
Grateful, Your Lordship. And then the next point is the timing.
15.
The timing.
What about 15?
Your Lordship, that's sort of a part of repeated original request 14, because it talks about communications and documents regarding the reasons for the termination of the claimant's employment.
Do I need to make any order about it?
No, Your Lordship.
Yeah, okay.
That's covered by.
I'm sorry, we've just moved through a number of things quite quickly. I just want to make sure that I have kept up. Request 14 and 15, as I understand.
Agreed.
No further order on either of those. Nothing's being pursued on either of those.
Nothing being
of course.
It'll be covered by the statement.
Yes. Yeah. Both of them are existing categories, and so no further order is being sought from Your Lordship in respect of those two categories at this hearing.
At this hearing, yeah.
Yeah.
So whether you want to call that not pursued or dismissed with liberty to apply, it doesn't really matter, so long as it's recognised that there is the opportunity of coming back if there are obvious gaps.
Yes, it doesn't make much difference whether it's my learned friend withdrawing it or my lord dismissing it. It's the same outcome.
Yeah, but I leave you to work that out between yourselves. Miss Ahmed, it's up to you whether you want to withdraw them with liberty to apply or have them dismissed with liberty to apply, or simply no order with liberty to apply.
Your Lordship, no order with liberty to apply, because it sort of feeds into the document production statement point, namely that the issue was that it was considered that the disclosure in relation to these documents was inadequate, even though there was no objection to them by a learned friend, and therefore we required a document production statement for disclosure of these documents.
Okay, so I'll say no order with liberty to apply in that category of documents.
Grateful. Yes, we are. And then
Mr. Trotter, you're happy with that formulation?
I mean, in the end, it's all the same. It strikes me that there is relief being sought, and it ought to be disposed of one way or the other. But I think no order means that's the disposition. There's to be no order on that part of the application, so I'm content with that.
Right. What else is there?
Your Lordship, I moved ahead. Two other small issues. The first one is the inspection point about the KS documents. Now that has been dealt with on receipt of Mr. Swangard's witness statement. We require inspection of the devices on where these documents were found.
Why do you want inspection of the devices? Because unless you've got some basis for doubting the authenticity or veracity of the documents,
We do, Your Lordship. We doubt the authenticity and of the documents.
Do you have a basis for it?
Well, the claimant's instruction is the claimant says that he doesn't recognise these documents and he wasn't a party to them. And it's not clear.
Where do I find that in the evidence?
Well, Your Lordship, the whole purpose of this line of inquiry has been in the context that these documents are not agreed. The authenticity of these documents are not agreed. And that's why we inquired after the native form and the metadata of these documents, and also with regards to where these documents came from. I mean, what Mr. Swangard says about his witness statement, in his witness statement, and maybe I can just take you to that, in fact.
Yeah. Paragraph.
I think it's 101. Page 100.
Don't give me those pages.
102. I beg your pardon.
Paragraph 100.
101. So this refers to the KS email.
Oh, yeah.
The document was disclosed in PDF format, and the defendants have since located the native form email. And the context to this is that the KBH sent a letter on the 13th of December, or rather even before that, and I can pull it up, asking about the native format of this document because it wasn't agreed. And also attached to that KS email was an excerpt of a WhatsApp document. Yeah. And on the 13th of December, we asked for the provenance of these documents, asked for native metadata, including the recipients, the participants, especially to the WhatsApp chain, the timestamp, because all of these details are missing from the document. And it might be helpful, Your Lordship, if I perhaps take you to that document. It is in the bundle. Do you know where it is?
Be quick. There's a limit to how long we can go on for.
And Your Lordship, I'll come back to where that document is, but coming back to Mr. Swangard's witness statement, 102 to 104,
yeah,
we make 4 simple points, and that is that the defendant's explanation is vague, and really it's quite inconsistent with their obligations to preserve relevant documents. The disclosure, or rather the rules, provide for a retention policy, and all of that will be set out in Malone and Friends document production statement, or the document production statement on behalf of the defendants. And in particular, it's RDC 28.20, which refers to providing parties information about document retention policies. And so, given the vague explanation provided by Mr. Swangard, we don't have any details about these devices, when they were returned or when they were repurposed, whether or not data was preserved, was it backed up? If so, where was it backed up? Especially in the context of the rules where the defendants are required to preserve evidence. And therefore, it's to that extent that the explanation isn't accepted, and therefore inspection is, we say, required of the devices on which these documents were found.
I thought the email was from whom?
It's from Ms. Katrina. I did have a reference in the bundle of where it is, but my reference is wrong. And so, pardon?
Is this Katrina Slobodeniak?
Yes, 388, I'm being told. Where's the email? So the email is at 387. Now, Cody Caitlin, or Caitlin Cody, was the legal representative employed by Clyde & Co., the former representative. Is that right? And this is said to be sent to the claimant.
It's 387.
387.
Yeah. Did you see? Right.
And Your Lordship, we don't have any details about where this has come from, who the participants are, and in fact, what pleaded point it relates to, apart from that there is a generalised allegation in paragraph 75A1 and 75A2 that there was some sort of misconduct, but yet we don't know what the relevance or materiality of this particular document is. And yes, whilst the claimant can make submissions to the court as to the weight to be given to this document in the absence of any information or detail about the point of all of this, we say if it is in production, unless either defendants can withdraw it, or if they don't and they still seek to rely on it, which it's assumed that they are, then there needs to be more explanation about why it is that they can't find this email or this WhatsApp from Ms. Katrina's devices, and information about when those devices were returned or repurposed, why wasn't data preserved, and so forth.
Right. Okay, Mr. Trotter, what do you say about that?
Well, my lord, this is opposed. We don't accept that it's appropriate for the claimant to go roaming around devices under our control and conduct inspection and in order to find some documents which they think might exist. Can I start by just looking at the documents, because there's one other document in respect of which a similar request has been made in correspondence just the day before this hearing. If we start with page 426 of the bundle.
Yeah. Pregnant with you.
Yeah. Oh, well, I wasn't going to read it out, but there we are.
Okay, sorry. It's confident.
It's not, my lord, but I wasn't. In any case,
there we are.
That's in December 2021. Then if we go back to 387, this is a few months later. And this is an email from Ms. S.
From the same person?
Yes, from the same person to the claimant.
Yeah.
And what we see is that there's a series of WhatsApps of an intimate nature.
Yeah.
And then one sees in the subject line, it says, "And yes, I have all." So the implication is...
Where do I find that?
I see on page 387.
Yeah.
The subject line.
I can't see, yes, I have all. Sorry, I'm being thick.
No, not at all. So we have the from not within the WhatsApp, but in the top of the email.
Oh, I see.
It's from the sender, sent the date to the claimant, and the subject is...
Yeah, I'm with you, yeah.
Yeah, and yes, so the implication is I've got all of these WhatsApps, all of these intimate WhatsApps. And my own friend asked me, why is this significant? And there was a suggestion made yesterday, although not repeated today, that none of this was pleaded. Now, if I can show my lord that in the amended defence, page 193. So this is the defendant's case brought in by way of amendment, to which my learned friends consented without objection. That says that insofar as
what paragraph?
There was an employment contract, then the claimant breached the implied duty which the claimant themselves alleged that we owed.
What paragraph?
And 75A.1 over the page, right. 194 is the relevant one. And we have that, so the claimant was in a romantic relationship with Ms. S.
Yeah, I see it, yeah.
Yeah, it's a conflict of interest, and then arranged benefits for her. Now, it's important to look at what the reply is to that at page 207, because of course it would have been open to the claimant to admit the relationship and then to say, well, but nevertheless, I didn't act improperly and everything that I did was perfectly bona fide. I disclosed the relationship or I didn't confer benefits or whatever, but that's not the case that's been run. So if we look at paragraph 14.2 on this page, paragraph 75A.1 is denied. So there's a denial that there was any such romantic relationship. The claimant therefore had no conflict of interest.
Yeah.
So that is the case. That is my learned friend's case. So it's squarely an issue. And it's now being said in correspondence and in submissions this morning that these documents are inauthentic. Now, it's quite unclear to us what the basis for that is, or indeed what the nature of that submission is. We don't know, is it being suggested that the defendants have fabricated documents? Seemed to be suggested this morning that someone at Clyde's might have had something to do with it.
That's not what was said. That's not what was said, Mr. Trotter. I'm sorry to interrupt, but that's not what was said.
Okay.
Well, I'm glad to hear that. That is the suggestion that Ms. S was responsible. Is the suggestion that the documents are genuine, but the contents of them are false. It's all very unclear. Now, these documents were produced in the defendant's standard production back in June. These requests have been raised very recently. But in any case, this will all be dealt with by production of the other communications between the two, because the claimant has asked the defendants to search for all documents and communications between the claimant and Ms. S. And we have agreed to conduct that search. We have requested that the claimant conduct the same search, because presumably if there are such documents, they'll be within his control. And the claimant has not responded to that request. So we don't know whether he is going to accede to the same request he's made of us. But that's where we are. So there's really two issues that arise.
What you say, I suppose, your submission is that until the whole exchange of emails has taken place, and the context in which this does or does not appear is clarified, then any order is premature.
Well, that's certainly the first thing that I say. I entirely embrace that. But in any event, on a more granular level, none of this is warranted, because there's really two issues that one needs to separate out here that's been sought. The first is production of original documents. And so we've been asked to produce the native documents with the metadata and so on. And this is a case where, as I say, we're not sure what the basis for it is, but there's an allegation of inauthenticity. And so they want to see the metadata. We understand that. And we have produced the email with the metadata. And for the WhatsApp, we've explained that we don't have the WhatsApp as a second file, because my lord just saw that the reason the WhatsApp screenshot exists is that it's an attachment to the email that came from Ms. S to the claimant.
Yeah.
So that's where that document has come from. It's been produced as an email with an attachment. There's nothing in that to suggest that somewhere we have the broader WhatsApp thread. In fact, the very contents of that email, as we saw a moment ago, is Ms. S threatening the claimant that she has the full set of WhatsApps. So there's no real reason.
That's one interpretation.
That's quite right. That's one interpretation. Now, Ms. S has left the defendant's employment. This is all explained by Mr. Swangard, and her work devices have been returned, repurposed for parts or reissued. Those returned to the leasing company, repurposed for parts or reissued. So if the WhatsApp came from those, then we just don't have the original. We've searched for it and we don't have it. Now, Mr. Swangard also pointed out that it would be very helpful if the claimant could identify what other means, if any, he used to communicate with Ms. S, because that might assist us to find any such further communications. Well, that hasn't been done. And might be worth just, in a learned friend's skeleton argument, seeing what is said about that. So paragraph 103. On internal page 28.
Yeah.
So at the bottom it said, the defendants argue that the claimant is better placed to provide information about the WhatsApp, such as phone numbers. The assertion is unreasonable and a misplacement of the burden. Well, we've searched, but with respect, the idea that it's too burdensome for him to tell us how he was communicating with her is unhelpful, at least. But as for production, the first point, everything that can be produced has been produced. Then there's another question about inspection. And there's a suggestion that my learned friend should inspect the original documents in their original form. And my lord, there's really 2 points about this. The first is that, so far as concerns electronic documents, it's very difficult to see what my learned friend will understand from seeing electronic documents on the device where they were originally hosted. So looking at the email that we've given them on the computer where it was found, as opposed to looking at the email in its native form with all of its metadata, because it will have all of the same data within it. And it's not like looking at an original hard copy document to inspect signatures, test whether there's imprints on paper and so on. So that's the first point, is it just doesn't really help with electronic documents. But the second point is that my learned friend goes further than that, because the claimant doesn't just want to inspect the original document. The claimant wants to roam around the original device. And we see that again in my learned friend's skeleton argument at paragraph 57. Sorry, that's a bad reference. Paragraph 113.
113. Yeah.
And so there's something said about Swangard 1 and 113. 114, the inspection rights are fundamental to contest the allegations. And then 115 is what the claimant seeks on inspection of the documents, and then an order about adverse inferences. So there's not in that passage of the skeleton argument any suggestion that they're going to be able to look through the devices themselves, but certainly in correspondence, and what I understood my learned friend to be saying this morning, is that they want to look at the devices and search around generally to see if there's any other documents that might be of assistance. And the problem with this is one far more fundamental, that it just turns the entire exercise of disclosure on its head and involves the claimant's solicitors attempting to do our disclosure exercise for us. It's entirely inappropriate. It's not even the norm when a search order is made, when it's still just to preserve documents so the party can conduct their own disclosure exercise. So there's absolutely no warrant in principle or in the circumstances of this case for an order of that kind. And now, finally, there's some suggestion that we ought not to be relying on these documents. I'm not going to deal with that now. If my learned friend wants to make submissions at trial.
There's no application to stop you relying on them at the moment.
No, quite.
Your Lordship.
Do you want to say anything else, Ms. Nollet?
Yes, I do, Your Lordship. If I may just take this in stages. The concern with these documents were that there was no information about where they came from, the recipients of the WhatsApp, or the participants rather of the WhatsApp chain.
Yeah.
And presumably this WhatsApp chain was in a document that belonged to the defendants, and Swangard 1 says as such. So that was the first point on the concern with these documents. Now, in terms of asking for metadata for them, there doesn't necessarily need to be a suspicion of fraud to ask that. The parties we say are entitled to ask for metadata, particularly where there is a question mark over the document, the provenance of the document, and where the document has come from.
Well,
the third.
Yeah, but sorry, cutting across you rather rudely, but quite apart from those points of principle, if in the course of disclosure you are going to conduct a trawl of your client's WhatsApp account and email account, then surely in the context of that, it might be appropriate to look at seeing the further metadata for the WhatsApps on this page. I mean,
Your Lordship, the claimant has already disclosed WhatsApp chats. And I think in the region of, I mean, I can't give you the exact nature of the documents, but the chain of WhatsApp chats is in the region of about 12 or 13 threads dealing with various individuals. Now, of course, Your Lordship, in those chats, there hasn't been any disclosure of any WhatsApp chats with Ms. S. But of course, we can go back to the claimant and take instructions on that. But coming back to the obligations and duties on the defendant, again, Your Lordship, not wanting to be too monotonous, but going back to the rules, Your Lordship, the defendants are required to preserve data and preserve devices upon which that data is contained. And unfortunately, what Mr. Swangard's witness statement does is give a very flippant explanation as to what's happened to these devices, that they've been repurposed or given back, but without actually giving any detail. And so when one again goes back to the rules as to what the defendant's duties are, and I don't think I've taken you to this provision. So, Your Lordship, 28.40, this is in the context of an application being made for a document production order. And there's an obligation on the defendants, as the party from whom the document production order is sought, that it should provide to the applicant and to the court information as to the factors listed in Rule 28.21 and his document retention policy, to the extent such information is relevant to the application and has not already been provided. And 28.21 you've been taken to already, and that is the reasonable of a search in terms of the documents, any electronic search, and it gives factors 1 to 3. And I won't bore you by reciting those again. And then it goes back to 28.20, whereby the defendants ought to provide information of the retention policy. Now, none of this has been provided, and it's been provided if it has, then it's very late in the day, because the request for these KS documents was first made in early December. There was no response to providing metadata or providing any details about these emails or the WhatsApp chats. The only detail that was then provided was very late in the day once the application had been made. And therefore, despite the explanation that's being given, we say it's vague and we really require more information about these documents, particularly if the defendants relying on them. And what we don't want is what Mr. Trotter is suggesting, to do a trawl around their sort of devices. But what we are interested in is the chain of custody as to where this email has come from. And the reference to Caitlin Cody was simply that this was provided to the previous representatives. So it must have been provided prior to the 19th of August. And therefore, it's not clear to the claimant how this was produced, where it was produced from, the original device from which it was produced. When Mr. Swangard says that the devices have been repurposed and so forth, when did that happen? And in that context, has the defendants complied with its retention duties under the rules?
Okay.
And furthermore, has this, I mean, what's happened part of the extraction or production process with regards to this email?
I'm just trying to identify what your case. First of all, explain Caitlin Cody again.
So Caitlin is, as I understand, the legal representative. She works for Clyde & Co. And Clyde & Co. were the legal representatives, former legal representatives, and they came off the record.
How does her name get onto this document?
Well, this is the point, because when was this given to the former representatives?
Forget about when and where and how. But how does her name get onto this document? It's not sent to her, is it?
We don't know.
Her email address isn't there.
Oh, I'm being told that it's because she must have printed it from her inbox? From her
If it's from her inbox, it would have her email address. Do you think?
One would
If she PDF'd it from her inbox.
I'm being told if she's PDF'd it from her inbox. I mean, I don't really understand how that would work, but the concern is the chain of custody of this email. So where did it first come from?
Well,
it's been said that it's Ms. S's device. What's happened to those devices?
Can you can you tell me, is it your client's case that there is no WhatsApp communication between himself and SK at the relevant time?
As I understand, but we can go back and I can take further instructions on that. But as I understand, that is the position.
If you are able to show by other material that there are genuine doubts as to the authenticity of this document, that might be a matter of justifying going to the inspecting the machine on which it was transmitted. But unless you can do that, well, I can't quite. It seems rather premature to interrogate this WhatsApp and this email.
Well, if I might perhaps provide a more, I suppose, constructive approach. My lordship's going to order a document production statement, and therefore it's the duty, it's an obligation on the defendants to provide such a statement in accordance with the rules 28.40, 28.20, 28.21, and it may be of more utility that once we receive that document production statement, we'll be in a better position to assess the nature and provenance of and the chain of custody and retention of any sort of retention policy that the defendants may have, and maybe we can interrogate it at that point, Your Lordship. And I'm happy to leave that there, subject to the timing.
Am I ordering a document production, making a document production order?
Well, we certainly invite you to do so, especially given the timing.
Is that in respect of this document?
Well, it's in respect of generally all the requests, Your Lordship. So the requests under the reformulated RTP.
I thought the statement I was giving was one under 2820.
Well, the document production statement, well, in terms of the scheme of the rules, 28.1020 sets out the document production statement and what it should include. Yeah. 28.40 then skips to the sort of document production statement, or rather information. So let me just read it out. The party from whom a document production
don't just read it out. I can read it to myself if you want me to read it.
Yes, please do read it, because what we say that the factors then listed in Rule 28.21 also become relevant and also form part of the statement, the document production statement that the defendant has to provide. And that refers to retention policies.
Okay, I've read it.
And then, Your Lordship, it's the timing of when all of this should be provided. I don't think we've had any sort of discussion as yet. I've referred you to Mr. Swangard's witness statement where he indicates that they would be in a position, if they say 14 days from the date of the witness statement, and the witness statement is dated the 31st of December. And so 14 days from there is when they would be able to provide
next Tuesday
documents. And I would say that that should also apply to the document production statement. So it's 11.3, page 66. In sum, the defendants estimate that it will take about 2 weeks from the date of the witness statement to review outstanding documents, finalise document production and file a document production statement.
Okay. Well, I would not just say for the moment, I'm not minded to make any specific order in respect of SK, whatever it's called.
KS. Katrina.
KS. But we needn't have names.
Yes, and Your Lordship, apart from the issue of costs, we say that that's the entirety of the request sought by
except for the timing of the what orders do you want as regards timing?
Well, we say the admitted position by Mr. Swangard that the defendants need 2 weeks from the date of the witness statement. So that would be the 14th of January, which is Tuesday. Is it next Tuesday? Yes. Next Tuesday.
Happy with Tuesday, Mr. Trotter?
Well, my lord, there hasn't been a lot of further burden added in the course of this hearing, but there have been a few reformulated narrower requests which have been ordered. And I've just been taking instructions on how long it's therefore likely to take, because it of course makes sense to give the document production statement at the same time that document production is complete.
Yeah.
And I'm told that another 2 weeks beyond Monday, so perhaps that takes us to Monday the 27th of January. Again, we've had for the document production statement, and there's such further document production as has been agreed and ordered in the course of this hearing.
But Mr. Your witness, sorry, I keep forgetting his name. Mr. Swangard had already prepared some documents almost ready for release, hadn't he?
Yeah, certainly we will continue to give document production in tranches as we have done.
Yeah.
And I don't say that everything will be held back until then. The financial documents should come much more quickly than that, and there'll be another tranche of the final review set much more quickly than that as well. But
the ones already mentioned by Mr. Swangard should be available by next Tuesday or Wednesday, shouldn't they?
I think if we could have
and then the final date on the 20, whatever it was you said.
Yes, perhaps if we could have until the end of next week, that might assist. I'm afraid this hearing has proven to consume a fair amount of resources in itself.
Yeah.
And so if we could have until next Friday for the existing stuff.
What date is next Friday?
That's the 17th.
And then what was the date you then suggested? 2 weeks from today?
27th.
So
2 weeks.
as much as possible.
Isn't
No,
2 weeks?
That was 2 weeks from. Was
From Monday.
2 weeks from Monday, yeah.
And if it said whatever's presently available by the 17th.
Yes.
And complete production so far as possible by the 27th.
Yes, my lord, we're content with that.
And your production and your document production statement by the 27th.
I would expect that should be fine, yes.
Happy with those, Ms. Ahmed?
Yes, my lordship. Can I just clarify again what's being said here? So, and that's just with regards to the other procedural directions, witness statements, and I think it's the experts as well, has been shifted to the 24th of January. I'm just looking at a consent order. It's at 289. I think that only deals with witness statements and hearsay notices. So, and the original order for experts was the 24th of January. And what my learned friend, as I understand, is proposing that the 250 financial documents, those can be disclosed by the end of this week?
No, by the 17th. Is that this week? No, it's next week.
That's right.
My lordship, if those documents are ready to be disclosed and we've agreed the confidentiality ring order, I'm not really sure what's prohibiting the defendants from disclosing them ASAP. Why can't they be disclosed at the end of this week, the 10th?
Mr. Trotter, if they're already been made identified and collected and all that.
I'm being told that's fine from behind me. Of course, the confidentiality ring order will have to be sealed and undertakings have to be signed and so on, but that can probably all be done quite quickly.
So the end of this week is, today's the what? Today's the 8th.
So it's the 10th.
Well, why don't we give it till Monday?
That sounds sensible.
Because our expert is probably quite industrious and might be working over the weekend. on the expert report.
Can you get them by Friday, Mr. Trotter? For this industrious expert?
Well, warms my heart to know that my learning friends team is all as industrious as her. I haven't received any objections, although there is a comment being typed. Yes, that's fine, I'm told.
Okay.
Great thought for that.
The documents that are presently available to be disclosed by
4
10th
p.m.
of 4 p.m. 10th of January.
Well,
Friday.
I need to separate out here. The sensitive. Well, yes, I'm content with that formulation.
That includes the 250 financial documents.
Yes, that's
Yes.
what we're.
Yes, there's of course the other pool of documents that's still being in the final stages of review. I don't think I can say confidently that they will be ready for Friday, but we'll certainly disclose them as soon as practical thereafter.
Yeah,
Yes.
so just to clarify, so it's the 250 documents that are ready to be disclosed, and we've dealt with the confidentiality ring order. Those will be disclosed by 4 p.m. the 10th of January.
The remainder as soon as reasonably practical thereafter, but in any event not later than 27th.
Yes, quite. That's the date by which disclosure should be finished.
Well, Your Lordship, I've got two points to make there. So I'm going to say there's two classes of documents here. The ones that Mr. Swangard refers to at paragraph 11, which is those that are responsive to the original categories, and those were the extra 6,200 documents that Mr. Swangard said they would be ready to disclose on the 14th of January. So is there any reason why that class of documents, the 6,200 documents that were being reviewed, can't be disclosed on the 14th of January, given that Mr. Swangard said they could? So that's the class A.
Which paragraph is that of Swangard?
11. If you look at paragraph 11, 65 at the bottom over to 66, 11.1, 11.2, 11.3.
Yeah, all right.
So we say that those should be disclosed by the 14th of January, and then any documents responsive to the reformulated requests today, I think, is my learned friend saying that the defendants will be ready to disclose those by the 24th of Jan.
27th.
27th.
What about?
And then sorry.
Hang on, let me find out one thing at a time from Mr. Trotter. The middle position, the documents referred to by Mr. Swangard in paragraph 11, 5,738, I think.
Yes, my lord.
Those are 200. They can be done by the 14th, can they?
My lord, there are a number of very unfortunate people working through those documents at long hours of the day. As I said a moment ago, this hearing has consumed some resources, and I think it would be sensible, and we'd be very grateful if my lord would allow until the end of next week, the 17th, for those documents.
Okay, so how are we going to describe those documents referred to, currently being reviewed as referred to in Swangard paragraph 11? To be disclosed by the 17th, you say?
I'm content with that.
All remaining disclosure to be by the 27th. And
then, Your Lordship, if we look at the timetable generally, and that is witness statements to be disclosed on the 24th, I wonder if there's any leeway to extend that whilst we're looking at it, to allow the claimant to take into account the disclosure that's going to be complete by the 27th of Jan. And I don't know whether or not the timetable allows for that. So I think it does, although of course it's quite tight. Bring up the CMC order again.
Where do I find that about page?
Page 285. Or 286 deals with witness statements. So of course, paragraph 9 has now shifted, and the current agreed position is 24th. Reply witness statements. 10 is the 14th of Feb.
So you're suggesting everything goes back by what, a couple of weeks?
Yes, Your Lordship. So
Is that going to lead to trouble later on?
24. I don't think it is. I mean, the expert evidence stands distinct in any event. And so let's say the 24th of January is shifted to the 7th of Feb. And then
That's 2 weeks, yeah.
And then the 28th of Feb for the reply witness statements.
What date are the witness statements now?
So first round is the 24th of January, reply witness statements the 14th of Feb.
Right.
And so I'm suggesting that the primary witness statements are filed and served on the 7th of Feb, with reply witness statements on the 28th of Feb, and then the trial itself, I think it's the latter part of March. Yes, the 21st of March.
Yeah. Okay. So we'll see what Mr. Trotter says about that.
Yes, sorry. I think this is pushing things far too close to trial. We're going to end up with witness statements being served with only 3 clear weeks, not even 3 clear weeks before the start of trial.
Well, that's supplementary witness statements, is it?
Yes. Yeah.
Yeah.
So I mean, I'm content for a bit of time to be built in, but we really are very compressed at this stage.
If it's like 1 week rather than 2, would that help?
I think it would, and so where that takes us to.
I don't have the dates in front of me. Yeah.
But
Yes. If we were to push currently it's on the 24th. If we were to go out 1 week, we'd have the 31st. There's also currently a 3-week gap between primary and supplement, so 2 weeks might be sufficient. So it may be that all that really needs to happen, at least at this stage, is to move the primary witness statements to the 31st. And if that really turns out to be unworkable, then we can readjust. But I'm very reticent to compress this timetable anymore, because one does at some point need to prepare the actual trial.
Yeah.
Can I suggest this, Your Lordship? Oh, sorry, I beg your pardon.
You're gone.
My apologies, Your Lordship. I was going to suggest, if we push out the primary witness statements from the 24th to the 7th of Feb, which gives us 2 weeks, rather than the reply witness statements taking 3 weeks, maybe we only allow 2 weeks for that. So that comes back to the 21st of Feb. And then that hopefully deals with Mr. Trotter's concerns.
Does that deal with your concerns, or do you prefer to have it a week earlier?
I think my preference would be to have it a week earlier. And so this time that was already far more compressed than any other case I've ever done. So I think it would be better.
It got stuck in the middle of last year somehow.
Yes, I seem to recall that. So I think leaving it 1 week earlier would be better. One can always extend if things get sticky, but it's impossible to wind back the time.
I rather agree with that approach. So 31st January then for witness statements, and
that's right.
And 2 weeks after that for supplementary.
Your Lordship, at the moment it's 24th of January, and if disclosure is going to be finalised on the 27th of January, I'm proposing the primary witness statements are on the 7th of February.
I know you're proposing that. I was disagreeing with you.
Well, I misunderstood in which case I misunderstood the dialogue that was taking place. My understanding was of Mr. Trotter's criticism was that it didn't leave him enough time to prepare, but we're talking about the reply witness statements being later rather than the.
Yeah, okay.
Because I mean, even if we push out to the 7th of Feb, that still gives Mr. Trotter at least, well, just under 2 months, because the trial's on the 21st of March.
I reckon that's about 7 weeks, 6 to 7 weeks. Yeah. Well, look, let me write down a date or two. Present order is for what? Witness statements by when?
24th of January, the primary witness statements, and then supplemental or reply witness statements 14th of February. That's the current order agreed between the parties.
Okay. So if you
and if production is going to be concluded on the 27th of January, and by the time it takes us to review everything and work out what's relevant for the witness statements, I'm then proposing that that we have 2 weeks to do that, and so we file and serve the primary witness statements on the 7th of February.
just give me a second.
6, 7, 8. That just gives us 8 working days in which to consider all of the new disclosure that's being made and factor it into the witness statements.
Well, what we could do is we'll keep the supplementary witness statements at the 14th February. And what about making the initial witness statements on the give you the extra weekend and on the 27th, which should be give you about 5 days after the supplemental discovery.
Does my lord mean
Sorry,
the third?
Sorry, Your Lordship.
Sorry,
The final disclosure is on the 27th of Jan.
Oh, right.
The
Sorry.
current, yes. And what I'm proposing is 8 days to deal with the supplemental disclosure, and we file and serve the trial witness statements on the 7th of Feb for a trial on the 21st of March.
Why do you need, sorry, if the end of the disclosure period is 27th, then what's wrong with the 3rd of February for witness statements?
Well, Your Lordship, we're not entirely sure the volume of documentation at the moment.
You can work out what's relevant to the witness statement there.
Well, Your Lordship, the 3,000, I mean, it took us weeks to look at the documents that were already disclosed, the 3,000 documents. Unfortunately, the claimant doesn't have the battery of lawyers behind him. The defendants do.
We don't need to go into that again.
Well, I mean, Your Lordship, it is a factor to be taken into account.
Yes. Yeah.
I mean, the claimant has a far smaller team and a far more, and so.
I have your point, Miss Ahmed. Really, I do. I've heard it a few times. I've read it. I've taken it into account.
I won't bore you again with it then.
I'm anxious that we shouldn't leave the supplementary witness statements too late.
In which case, Your Lordship, what I am proposing is the 7th of February we have for the trial witness statements. And then the supplementals, we have 2 weeks or even 1 week. Or rather, sorry, 2 weeks to put the supplemental witness statements together, because currently the deadline for the supplementals is the 14th of February. That's been agreed by consent with the defendants.
If you made that the 19th rather than shifted it a whole week, 19th, and then had the first round witness statements on the, what are they at the moment?
First round at the moment is 24th. I'm proposing the 7th of Feb.
If you had the 7th for initial and 19th for the supplementary, how would that strike you, Mr. Trotter?
Well, for our part, we much prefer the timetable that my lord proposed. And just to run through the dates, the disclosure is coming, the current review pool disclosure is coming on the 17th.
Yeah.
We then have the handful of things that have been ordered today on the 27th. But those documents are all about the scheme of transfer of other employees, the establishment of Liberty DIFC, and so on. They're not really documents that are going to be very helpful for the preparation of witness statements. And in any case, quite a lot of progress can be made without them in the meantime. If there is anything useful, they can be addressed.
And that's the 27th, is it?
I'm so sorry.
That's the 27th, is it?
That's the 27th. And so it seems to us that my lord's proposal with witness statements the Monday following that on the 3rd of February is perfectly sensible, because it would then allow us to maintain the 14th of February for supplemental witness statements. That means we don't have further slippage in towards a trial that is starting not that long thereafter. So I'm quite anxious to maintain that gap. And as I say, if it turns out that it's impossible, then the parties can liaise about further extensions if it really becomes necessary. But it's impossible to wind the time back. Once it's gone, it'll be gone forever. So we think that my lord's proposal is a sensible one.
But Ahmed, I think to keep the trial date, you're going to need to do something like that.
Well, Your Lordship, just to inject a bit of humour, I'm quite impressed with Mr. Trotter's philosophical sort of statement on when time's gone, it's gone. But coming back to...
I was wondering about
that. Your Lordship, I mean, is a couple of days really going to make much of a difference to Mr. Trotter? I mean, he suggested that...
Same could be said about you.
I beg your pardon, Your Lordship.
Same could be said about your side.
Well, Your Lordship, we say that it will make a difference given the production and the work that's involved.
I'm going to make an order for this witness statements of the 3rd, supplementary on the 14th. And if you run into a major logistics problem leading to an extension of a day or so, I don't suppose there'll be any difficulty in agreeing that with the other side.
I'm sure everyone will act constructively.
Okay. Anything else?
My lord, that's all the substantive relief. That leaves the question of costs.
Yeah.
I think we can take this quite briefly.
I think it's been quite a useful exercise, although it's been rather drawn out.
It has been very drawn out, my lord. It's been a very an application that was lobbed in on Christmas Eve, urgent work done over the period in a 2-hour hearing that started life as a document exercise on the papers has turned into quite a lengthy 2-day hearing. Now, the short answer for us is that costs should follow the event. And by and large, all of the requests have been rejected and the claimant has been invited to come back. The only exceptions are a handful of requests that were very substantially reformulated overnight. And in one case, on my learned friend's feet today, where we acted constructively and agreed something that could be produced. But overwhelmingly, I mean, just looking through the requests, compromise requests 1, 2, 4, 9, 13, 14, and 15. On all of those, the order sought by my learned friend was refused. And only on compromise requests 10 and 12 were orders made. And that was only because they were very substantially narrowed overnight. And then we had the issues in relation to the KS documents, where inspection and the like was sought. That was refused as well. And the confidentiality issues, which really ought to have been capable of resolution before the hearing, but weren't, and led to further costs. And we were successful on that part of the application as well. So in my submission, the defendants are the successful party by any measure today, and a significant amount of costs have been incurred. It's been a very significant distraction of resources at a critical time. And we do see our costs. I don't say it should be on the indemnity basis, but on the standard basis.
My lordship, it would. I beg your pardon.
Yeah, go on.
It won't surprise you that we consider that the claimant will get a proportion of his costs. And if I can invite you to look at page 7 of the application notice, because that sets out the reason why this application was made and the reason why the claimant was forced to make this application. Primarily, Your Lordship, and I took you to the correspondence, and there was a reason why I took you to the correspondence, because the correspondence reveals how disengaged the defendants were with what the claimant was asking of them. And it was only when the application was made that the defendants then woke up and gave us the answers that we wanted. But actually before that, and the reason why the claimant was compelled to make the application is not only were the claimant's requests ignored, but then the defendant threw a spanner in the works, informing the claimant that it was intending to change its legal representative. And of course, the claimant's been through that exercise in August when there was a delay. But page 7 of the application notice, I think, sets out quite sort of succinctly why the application was made. And the first point is that there was a failure to comply with the case management order, and that was that the production of documents was inadequate, or rather there hadn't been a complete production of documents, and nor did the defendants indicate when production was going to be complete. And it was the first time in Mr. Swangar's witness statement that was in response to the application on the 31st of December, the defendant said, well, actually, there's these 6,000 further documents, and actually set out the position of the defendants. But for the application, the claimants would still be in the dark as to what the claimant was doing about production, when it intended to complete production.
You say that, and I know there are some points you make with some force, but the other thing is, on some of the applications, some of the heads of application, you hadn't focused on what hadn't been provided. So, and that's why I rejected an overall restatement, as it were, of the particular claim. And it seemed to me that doing the best I can, I think each party has been responsible for some of the reasons that this matter had to come to court. And my very sort of Damocles approach is to say that each party should pay their own expenses, their own costs of this hearing. The alternative would be to reserve costs, but that's not very satisfactory, and they get lost in the overall scheme of things when you get to a hearing. So I think each party bear their own costs.
Your Lordship, we would ask for a reservation of costs, because all of that can then be dealt with by way of a detailed assessment at the end of the trial.
I gave some consideration to that, and for the reasons I mentioned, I think it wouldn't be a matter for taxation, or it would be a matter for the judge hearing the case to work out separately who was responsible for the various procedural applications, such as the disclosure request. And I think that would be very difficult for a judge when he's meant to be focusing on the substantive merits.
Grateful, Your Lordship, for the consideration. I have nothing further to add.
Well, thank you both. Thank you both very much.
The only one thing which might be usefully dealt with is my Lord may have seen that we have made our own disclosure application,
which can't be
which was issued a couple of days ago. There was a bit of a technological glitch getting issued. I think a hyphen somehow. Sorry, my other friend's not on mute.
Oh, I beg your pardon.
Yeah.
And we obviously seek to have that determined on an expedited basis for all the same reasons that this application has been. I don't know if that's come
I've been made aware of it. I've been made aware of it, but I haven't read it.
No, I wouldn't have expected that Your Lordship would have. So I'm very much in Your Lordship's hands. I mean, we would certainly seek that directions be given on that. I'm very much in your hands about whether that is done now or on paper later, once Your Lordship's had a chance to have a look at it.
How long is it going to take, realistically?
I think in view of how matters have progressed on this application, I ought not to be too optimistic, but I would hope that we could deal with it in a day.
Your Lordship, I don't think you ought to be troubled by this at the moment. That application, as I understand, hasn't even been served on the claimant. And certainly I've not had an opportunity to review or read it. And so, Your Lordship, if there is anything to be said, then that can be dealt with the registry who's in charge of these matters once the application is served.
My Lord, I don't want to get into all of the detail on this, but my learned friends have not been especially constructive on this, because the application was issued on Monday. It was copied to them. There was a technological issue about the court system not issuing the application, and my learned friends opposed the matter being brought to your attention and directions being given at that stage. Now, it's in everyone's interest that this moves along quickly, rather than being stalled on the basis that the application notice hasn't been formally issued and served. But the application has been submitted. It has been provided to my learned friends in the same form that it was provided to the court.
Yeah, I could do, sorry, I could do 22nd or 23rd. Is that too late?
I mean, either of those dates would be suitable for me personally.
Your Lordship, I'd have to check my diary and come back. I think there might be half term around about that time as well. I just have to check, Your Lordship. I'm afraid I won't be able to give a response on the hoof at this moment in time.
Okay, well, that's my suggestion. I'm saying it partly for the benefit of court staff who are from the registry who are in attendance, and they can make, if you can agree a date like that, the court, the registry can give directions as to the exchange of evidence and whatever.
Yes, of course. And we can liaise with Mr. Trotter and obviously his representatives on availability and directions.
Well, we can certainly do that.
Effective application.
Well, yes. Well, I would say that I'm not, in view of the way things have progressed so far, that confident that we'll be able to agree a date. But we will, if my lord's not willing to give directions now, then we'll chase it up with registry and try and get them issued as soon as possible.
What documents have you served so far? Sorry, not served, but have you tried to serve so far?
Well, we've provided the draft order, the witness statement in support, and the exhibit, and the text of the application notice. That was then all submitted through the system and has now been formally lodged and paid for. But the system has not yet generated the sealed version of those documents for service. But everything is being provided.
That was done when?
That was done on Monday. I think
Monday the 6th.
Monday the 6th.
And Your Lordship, I'm not being unhelpful. All I'm saying is I haven't had an opportunity to read that application at all. And nor can I provide availability at this stage. And I'm just hoping that we can. I mean, Your Lordship has indicated your availability. And
well, if you like, I'll fix a date then.
Well, Your Lordship, again, I can't confirm that date is sufficient. I'd have to go back and check. And Your Lordship, if those dates you're not available, I mean, I'm hoping there would be another judge to be able to deal with that. But it's just that at this moment in time, I can't confirm the 22nd or the 23rd, unfortunately. Okay. That's a problem when you have 3 young children and holidays.
Sorry to interrupt, Your Lordship. I can confirm that the sealed application notice was filed on the 7th of January. So that was yesterday.
Thank you very much. Thank you, Alia. Well, look, if we provisionally aim to have the following dates fixed, the claimant's evidence in response by the 14th, which would be Tuesday week, yesterday week, and a hearing on, if subject to availability, a hearing on 22nd or 23rd, with skeleton arguments by the 20th.
Thank you, my lord.
That seem about right? There's a normal sort of gaps, isn't it?
Yes, my lord.
If there's any difficulty that can't be resolved by the registry, you can ask them to put it before me for decision. But I would hope we can fit it in one of those 2 days.
That's very helpful. Thank you, Your Lordship.
And can we try and make sure we finish in a day? So, but not starting before 1 o'clock UAE time.
Yes, that's been well heard.
Thank you very much, both of you, and thanks for your assistance.
Thank you, Your Lordship.
Yeah.
Thank you, my lord.
Thank you.